Well. There were 120. It may be clear you should say you do have snacks so people want to make their way in. Do I need to? I'm going to speak to the mic.
Good afternoon, everybody. There are still Zoom participants joining one by one, so I'm going to speak slowly for a few seconds. We're up to 195 Zoomies, or whatever they're called. And I think over 400 people have said they wanted to link. So either the numbers will stop going up very soon because not everyone really wants to spend all afternoon on the Zoom link, or they're all very enthusiastic and it'll take another 10 minutes for everyone to enter. Hopefully not. In the meantime, thank you to everyone who's come in real life. It's nice to see actual humans. And oh, it's still going on. It's exciting, this. So I will just say a few words very briefly, one of which is about the emergency procedures that people on Zoom do not need to know about. Although if they want to find a nearby staircase and evacuate their building, if it happens to us, they're very welcome to do that. If there is an emergency in this building, then there are stairs next to the lifts, and you're not allowed to use the lifts. If it's an emergency, you'll have to go down 5 flights of stairs and go to the meeting point, which is opposite chambers where the hire bikes are, and wait there until someone says that you're allowed back in. There aren't any planned fire drills or anything, so if something happens, then it's real and need to make a run for it, but in a very safe and calm manner. So we're still going up on here, but I will crack on anyway because we've got a very strict schedule of timed talks. The topic obviously is the somewhat depressing, I think, topic of deprivation of liberty of children and young people, and both in the Court of Protection and in the Family Court. And there are going to be a number of presentations with a break at about 2:40 for about a quarter of an hour. And then the more important time to stick to is 4:30 when it finishes, and there'll be refreshments. And the aim at the moment is to have questions and answers at the end of all of the talks rather than part way through. So if you have questions that you're going to want to ask, make a note of them and or keep them in your head until about 4 o'clock when we get to question and answer phase. If you're listening to this online, then please put your questions in the question and answer box, and when we get to that stage, as many of those questions as we can get through, we will attempt to answer. We're very pleased to have not just members of the Chambers, but also external speakers for today's seminar. Senior Judge Hilder, who has just run down the road from First Avenue House to be here, Camilla and Alice Rowe from the Nuffield Family Justice Observatory. You'll hear from all of them shortly, but the first talk is from Anna Bicarregui, who, when I sort out this technology, will come and start with a general overview of these matters. There we go.
Good afternoon, everyone. I'm pleased to say I'm very much the warm-up act. So I am going to, do an overview of what we're going to be looking at this afternoon. I'm going to go through some of the typical cases that are seen for 16 and 17-year-olds in the Court of Protection and in the Family Division of the High Court under the inherent jurisdiction. And I'm going to look at the kind of what I'm broadly going to call the sort of typical approach that the court takes in these cases. Then Arianna is going to look in detail at some cases where the courts have refused to authorise deprivations of liberty under the inherent jurisdiction. So they're much more rare, but there are some interesting lessons to be drawn from those cases. And then TOR is going to look at what, if anything, can lawyers do about any of this, because it's obviously based on a really sort of difficult lack of provision in the first place. So let me turn then to, okay, why is this not working? Oh, it's working. I'm very proud of this slide because I'm not sort of a PowerPoint aficionado, but it does have one clear and glaring error, which I'm sure the more eagle-eyed of you will have already spotted. So Alex in his paper draws attention to this fact, but in fact, of course, it shouldn't say family court, it should say family division of the High Court. Alex has put something up which accompanies today's talk, which talks about 3 overlapping jurisdictions, so the family court, the family division of the High Court, and the Court of Protection. So, what are we looking at here? There is a concurrent jurisdiction for 16 and 17-year-olds who are for whom applications are made to deprive them of their liberty in both the Court of Protection and under the inherent jurisdiction of the High Court. This slide is absolutely chock-a-block full of law. I'm not really going to talk about very much of it at all, although other people are. So I know that Camilla and Alex, for example, are going to be touching on the difference in position for children who are under 16, where there can be consent by parents, but if they're looked after children, there can't be. So that's something which I'm not going to look at, but which is going to be touched on by the speakers. There's obviously, even if you just look at Supreme Court cases, there's a lot of law in this slide. So we know from VD, as I said, as Camilla and Alex are going to touch on, T, of course, in the Supreme Court, that you can use the inherent jurisdiction of the High Court to authorise the deprivation of liberty for children who meet the Section 25 criteria for a secure place, but where there is simply no secure place available. And also looking at transfer between the family division of the High Court and the Court of Protection. And that's something which is touched on by Senior Judge Hilder when she gave judgment in the Bolton case. And I put the quote up there, there is still much to be worked out. There's no real, so that there are cases going both ways, as is set out in Bolton. There's Headley in 2010 transferring to the Court of Protection, and then Mumby deciding in A to F that actually it wasn't appropriate to transfer to the Court of Protection. So there's a lot of law, but I'm basically going to be looking at mostly the practical aspects of this. And I'm going to leave, so I have no idea whether or not LPS is going to be scrapped, whether or not it's going to come in tomorrow. It may be that there are people who know more than me about this, and of course at that point the situation will change again. But for now, that's broadly speaking the position. So, turning first then to applications in the Court of Protection for 16 and 17-year-olds who lack capacity. Now, I've boldly put not COP Dol 11 with citing Bolton, and of course that's not exactly what it says, because it says that it's unlikely, the court is unlikely to consider the streamlined procedure is appropriate for applications of deprivation of liberty for 16 and 17-year-olds. So it isn't making a firm ruling that it's not appropriate, but it gives a very detailed set of reasons why in most cases the court is going to call in applications made for 16 and 17-year-olds. And that's for a number of reasons, but in a sense it gives the procedural safeguards that he is then joined, there's a litigation friend, there's notification to the family, there's judicial scrutiny, and the requirement that a Rule 1.2 ref is put in place at the end. So there's some discussion about whether or not, if it's likely that deprivation of liberty orders are going to be required post-18, it would be a better place to bring applications in the Court of Protection than under the inherent jurisdiction. But as we saw from Mumby and A to F, that's not necessarily the position that the inherent jurisdiction judges would take. So there's no real sort of firm rule in relation to these types of cases. And just quoting Bolton, I was hoping, as I said, to do this before Senior Judge Hilder got here, but sadly that's not been the case. But as Senior Judge Hilder says, the experience since December 2019 has shown that with the benefit of robust scrutiny by fully informed representatives of some of the applications relating to deprivation of liberty of 16 to 17-year-olds throw up very worrying issues in transitional arrangements in the respect of restraint, but others can be finalised by consent quickly. So I'm going to look then at some of the worrying issues and then some of the cases which are usually dealt with more swiftly. So restraint. Often in applications, restraint is mentioned, but without any real detail about how often restraint is happening, the training that people have in respect to restraint. And of course, this question is absolutely to the heart of what the least restrictive option is in relation to these young people. There's often no detail about any sort of positive behaviour support plans that could be drawn up, no multidisciplinary working, and all of this is the scrutiny of the court will allow all of these issues to be explored and to essentially provide a safeguard that restraint is the least restrictive possible before a dole is authorised. Of course, it's possible that a sort of high level of detail can be given in the application, but it's certainly the case in a number of cases I've seen that that kind of detail isn't given at the point of application, and therefore it's very useful to have the court scrutiny of that. And similarly, and this is referenced in the Bolton judgment, the transitional arrangements are important because you have a 17-year-old with an application, as I'm sure everyone will know, at 18 everything changes. So they go from being under the supervision of the sort of child social work team to an adult team. Accommodation will change because children's homes aren't registered to take adults over 18. And so there's definitely the possibility then that actually this is just going to have to come back with the restrictions may change. So again, the kind of scrutiny which the court can give in a substantive application rather than under the streamlined procedure is very useful. So that's just a couple of examples that are given in Bolton, but they certainly are examples which come up regularly. And then if we consider the sort of swift resolution cases as termed in Bolton, again, it's usually the level of detail that you see when the applications are made in this respect. So a very detailed level of care planning with a range of professionals involved, positive behaviour support plans if that's relevant to the young person, good evidence of lack of capacity, because actually that's sometimes not always present in the applications, and a kind of clear and considered look through all of the restrictions, whether or not they are the least restrictive, could they be modified in any way, and the whole team around the child's kind of considering those, and where there is a very high level of detail in the application, where the evidence of lack of capacity is clear, where family are involved in many cases, where P's representative is able to meet P and give good evidence, then those kinds of cases are capable of quite swift resolution, and I'm sure everybody's had cases which fall more in that category. I'm going to just pause for a minute on an interesting point which has come up before I go and look at the other jurisdictions, so the family division at the High Court, and consider the issue which recently came before McDonald about whether or not taking someone's or restricting someone's use of a mobile phone and other devices could constitute a breach of Article 5 and required authorization. It's an interesting judgment, and essentially, and I'm going to paraphrase it very quickly, Alex has done a really useful article in the newsletter on this one, but the short answer is that it's that taking someone's mobile phone away or restricting their use of social media or their access to different devices is not something which falls to be authorised under Article 5. Article 5, McDonald says, is focused very much on physical liberty, so you're in a certain place for a period of time you're unable to leave. He is very clear, though, that actually this kind of restriction is very much an Article 8 issue. So under another aegis, in terms of interest decision making, it does fall to be proportionate and necessary, any kind of interference with this. But I think what he sets out, probably better if I just read what he says, which is rather more eloquent on this point. It's important that the court be careful not to allow its jurisdiction to make orders authorising the deprivation of a child's liberty by reference to Article 5(1) to spill over into authorising steps that do not constitute a deprivation of liberty for the purposes of Article 5(1), particularly where those steps might constitute breaches of different rights, which breaches will be evaluated under different criteria. he does go on to make clear that if you have to use restraint to remove a child or young person's devices, then that's an entirely different matter. And that a separate order might be needed under the inherent jurisdiction if that were the case. But simply putting on, putting restrictions on which say you can't use it at this time or your access to certain websites is not allowed is a different matter. So that's, I think that's an interesting what comes up often in all of these types of applications for children and young people. Right. The other jurisdiction. I've reinforced the error here by entitling this family court. So again, the family division of the High Court. Now, as we know, there's a national dolls court in place. I'm not going to spend much time on this because actually Senior Judge Hilder has got some slides, I think, which are more up to date on this. I took this information from REX, which was the case that Sir Andrew McFarlane did in January 2023. And he thought that the annual total in the National Dolls Court might be around 1,000. And again, in that case, he reiterated that on any given day, there are 60 or 70 children on the waiting list for a secure accommodation place. So anytime that a local authority is looking for a secure accommodation place for a child, it's likely that the answer that will come back, well, we've got a waiting list of 60 or 70. So those are kind of the stark facts at the moment, although, as I said, Senior Judge Hilder has some more up-to-date from the children protection point of view information about that. So if we're looking at cases under the inherent jurisdiction, often we're looking at children who are under 16 who are in the care of the local authority. And I tried to sort of give some sort of sense of the kind of spectrum of cases that the National Dolls Court is seeing. So at one end of the spectrum, and actually both of these are cases which I've been involved in, so they are, and I'm sure they're fairly typical. At one end of the spectrum, you have a 15-year-old who is in an Ofsted registered children's home, which is registered as outstanding. They have multidisciplinary input. They are accessing education successfully. Their family is involved. They have an independent advocate. In fact, in this case, the picture was essentially quite a positive one. So the child had gone into care, but actually lots of things. When the guardian saw the child at one point and then came back 3 years later as part of this authorization, he said just that, you know, child had lost weight, was doing sport, everything seemed to be working really well. So at one end of the scale, that's the kind of case you're seeing, but still restrictions need to be in place. And at the other end of the scale is the type of case that a lot of the cases that we talk about in terms of no available options. So again, a 15-year-old who was on a hospital ward, the hospital was saying we have loads of infectious children, there's an outbreak, there was nowhere to go, there was no therapeutic input, she wasn't accessing education, there was very complicated family inputs, because the reasons I'm going to, she was under 5-to-1 supervision at all times. She had managed, despite the 5-to-1, to kind of get out of the room, to go up into an air shaft and broken her wrist. She was subject to long periods of restraint, and she was she was waiting a criminal prosecution because she had left her last placement by serious physical assault of another young person in that. So that's the kind of scale, and actually there's even more extreme cases that Arianna is looking at in some cases. And typically, both of those applications will be authorised. And they'll be authorised because, as the case law says time and time again, there isn't anywhere else, even at the extreme end of the spectrum, for those children to go. And if I look at some of the common issues, why is that? I mean, none of this is going to be a surprise to anybody. They're just, as I said, there aren't any secure accommodation places, there simply aren't enough, so the waiting list is long on any given day. There aren't enough registered children's homes. And as we know, one of the effects of, there can be criminal prosecution if you have a child if you're sexually running a children's home and you're not registered. And what that tends to mean is that providers will not take children until they're registered, which is very sensible, by the way, because registration gives a whole load of safeguards, but it means that the system becomes very delayed. I think Ofsted does run a fast track where a court essentially has placed the child in a placement that isn't registered, so they do try and get through those registration schemes faster, but nevertheless, there just simply aren't enough of them available. Tier 4 beds, talked an interesting case on this, where the kind of gateway, so if NHS England says that there aren't any beds, then it's almost impossible to secure a bed, despite anyone saying their child might need it. They're also quite short term, and increasingly, Arianna and I were saying that there's a kind of emerging, even for young people, this sort of, they have an emerging personality disorder, so it can't be treated, so they shouldn't be accessing a tier 4 bed. So there's all sorts of reasons why tier 4 beds are very, very difficult to access. And along with that, I think everybody knows the really difficult situation that CAMS is in. And so everywhere a child really does need access therapy in the community, that's not available. So every which way, there simply isn't anywhere for the children to go. And in that circumstance, the court will often sanction the least worst option. So I just wanted to, it's too much writing for a PowerPoint slide, but this is the kind of question posed, I suppose, at the end of this overview. Is the court rubber stamping the least worst option? Very often the court is told there's only one place where the child can be accommodated. The court's role is therefore very limited. There are no real choices for the court to make. The court cannot direct that placements should be made available. The court is not a regulator and cannot inspect potential placements or oversee care regimes. But this is the justice for. On the other hand, he said, even where there are no other placement options, the court does not merely provide a rubber stamp for the restrictions sought, and there are decisions to be made about the extent of the restrictions that are necessary and proportionate and in a child's best interest. However, the courts, like the parties, continue to be confined by the consequence of what Lord Stevens called a scandalous lack of provision, for which it appears there is no end in sight. It's a rather depressing case to end, but Arianna is now going to look at when the courts say no.
Well, I'm afraid I'm not here to offer much more than again I was offering, but I think we've got a couple of cases that we're taking a look at. This is also going to be accompanied by a paper which we'll put up on the website, which shows over cases in more detail individually and discuss some of the points in a little greater detail. What I'm looking at specifically here are 4 recent cases where, unlike Dan points out, the vast majority of the time, these deprivations of liberty are authorized, even though this is often very, very suboptimal. In these 4 cases, the courts made a decision not to authorize the deprivation of liberty. We'll discuss the extent to which there was or was not another alternative option available. I think it's right to say in no option were there any other good options available, and that was very, very clear. The other options were always going to be very, very dangerous for the children involved. We start off with the Wigan case. That was the case of Mr. Justice McDonald in 2021, which got a fair amount of attention because it involved a 12-year-old who was being held in an acute hospital in conditions which were described as brutal and abusive to the child. The other 4 cases are similar to that. 3 of them involved children who were not detainable under the Mental Health Act and had almost no involvement with mental health services in the community. The 4th involved a child who did have ongoing involvement with CAMS in the community due to a moderate learning disability and autism, but was again very much considered not a suitable candidate for inpatient admission under the Mental Health Act. And again, in all 4 cases, the hospitals were very, very clear that they could not offer anything therapeutic for the child involved, but the court wouldn't authorize this even on a short-term basis. So looking at some of the trends from these 4 cases, some of the things that are commonalities between them is age. In the 4 cases, the children were 12 or 14 years old. They were markedly young. So even by the standards of these sorts of cases, we're often seeing 15, 16, 17-year-olds. And these were very young children, and the court really did comment quite significantly on the fact that the consideration that it was giving was in part based on the vulnerability of the children due to their age. The detention settings are also notable. I was not able to find, certainly since 2021, any reported cases in which the courts had refused authorizations of deprivations of liberty in community placements. All 4 of these children were in hospitals. 3 of them were in acute hospitals, and 1 was in a psychiatric hospital. none of these children needed to be in hospital. 3 of them were brought in because they had been engaged in some sort of activity in the community which had led them to come to harm. For the most part, it was self-harming behaviors or suicide attempts. They had been brought into the hospitals. None of them needed any significant hospital treatment. They were all ready for discharge within a day or two, but there was nowhere, theoretically, there was nowhere for them to go back to. And children who had been in placements previously, those placements had given a notice and refused to take them back. And there were no other places that could be found that were immediately available for them. In terms of the backgrounds of these children, they did primarily relate to children who had experienced trauma and for which they had received little or no formal therapy or support. The children in these cases, many of them had experiences in care. Many of them had had very, very significant abuse and neglect with their families for the history of these cases began. So again, 3 out of 4, it involved trauma for which there was considered no appropriate inpatient treatment. And the 4th case, it did not appear that the child had experienced trauma. She just had a very high level of need resulting out of learning disability and autism. The cases also are notable in that 2 of them, the children came directly from their families. In the 3rd case, the child had only very recently left a very long-term foster placement. But for the most part, in the cases where these were refused, these were not children who had been in care settings for a very long period of time. They were mostly coming from family settings. They were also children who had been known to social services for a long period of time. And that's something that's very much commented upon in the judgment, was that these were not necessarily unanticipated problems that these children were having. Often for a period of months leading up to it, the child had been in some rolling state of crisis. Often the families had been asking for help, which certainly from the family's perspective, they did not feel they had been getting that help until something really serious had happened, like a very credible suicide attempt. In terms of consideration of mental health act, it was considered in all 4 cases. In none of the cases was the child considered suitable for detention under the Mental Health Act. And again, the very clear themes that I would say certainly reflect my experiences in similar cases when you're looking at children whose behaviors are attributed to trauma. In all 4 cases, the view was that an inpatient CAMS admission would be detrimental to the child, and no one was offering any inpatient admission for the children. All of them were assessed. Some of them were assessed repeatedly at the request of the court, but none of them changed the outcome in any way. In each case, CAMS took the view that going into hospital would actually be worse for the child. It would not result in any therapeutic benefit, and what all of these children needed were stable, secure placements in the community where they were going to have stable carers with them for a long period of time that would be able to help them with this. One point I will make, and it's not clear from the judgments, but obviously there's a lot going on in these judgments, so it's not really clear what the situation on the ground was. It's not obvious what mental health support was going to be offered for these children in the community, if any. What was very clear was that there had been very little input for at least 3 or 4 out of these children, and for the 4th one, again, it's not, they did have an ongoing relationship with CAMS. It's not clear how much actual direct contact CAMS had in the months of the rolling crisis leading up to this child being essentially left at hospital by her family saying they could no longer cope. The case of Blackpool Borough Council, which was one that Anna had mentioned before period, was an interesting case in terms of considering the interaction of cases of this nature with the Mental Health Act. And this one, Bicarregui went over in some detail framework for Tier 4 CAMS admissions. And he noted that its claim on the proper analysis of the mental health legislation and guidance, that even where an application for admission for assessment is certified by 2 qualified medical practitioners as meeting the criteria under Section 2, the provision of Tier 4 CAMS bed remains subject to the outcome of a referral that complies with the national referral and access process, which includes the completion of an access assessment undertaken by reference to criteria contained in the service application for Tier 4 CAMS service. And I think it is right to say admission for children is not like admission for adults. It is a very different process. And I think it's one that comes up in a lot of these judgments, and I think the Blackpool case is very helpful in terms of setting out how that's all to work. Bicarregui also noted in that judgment the role of the court is very limited. In many of these cases, the court has invited the relevant mental health trusts to be joined. They have invited NHS England, in some cases they've invited CCGs to come in and give a formal view to the court as to the appropriateness of the child's attention under the Mental Health Act. But it's not within the gift of the court really to create a mental health bed for a child. I have seen it suggested in some cases that I've been involved with that a child could be detained in a psychiatric hospital notwithstanding the lack of any detention of the mental health act. However, I have to say, I've never seen that actually come to fruition. And there have been many cases in which this has been looked at by different experts. But very often the answer is what it initially was. And I think overall there's often relatively little movement around that. In terms of considering some of the other commonalities of this, the conditions of detention in all cases are described in very strong language. It's noted in some of the judgments that the court will try to avoid superlatives, but these are the sorts of cases that call for those superlatives to be used. Brutal and abusive were words that are used frequently, and reading the judgments, it's very clear why these were used. In the Wigan judgment, this was a child who was at a baseline in the hospital, subject to chemical restraint, physical restraint, and 5-to-1 staffing, with times of more challenge behavior that was more challenging to deal with. 13 police officers present, restraining the child sometimes on a mattress or with the child handcuffed. All furniture removed from all of these children's situations. The involvement of the police is repeatedly mentioned. In one of the other cases, there were 7 police officers involved. In another case, again, 7 police officers involved. So very high numbers of adults restraining children. All of these children were on kinds of chemical restraint. All of them have had any sort of semblance of normality removed from the environment to prevent them from ligatures and things of that nature. Again, many of them being handcuffed. The conditions are very striking in all these cases. What's also striking is the stress that the children were experiencing, and it's very clear that these children were very likely being traumatized by what they were experiencing in hospital. One of the other things that's noted, again, in some of the judgments, is there were often rotating casts of staff coming in. Staff who were their training qualifications were not always known. It was not always clear that they had the required training qualifications. It was often a rotating cast of characters as well, so the child didn't have an opportunity to get used to anyone. In one of the judgments, it mentions the child going to sleep, and pretty much every time she woke up, there was a new adult standing in the room with her that she would have never met before, and how very distressing she was finding that. Again, in all of the cases, the view of the hospital was that this was making the child's situation worse, and that this was adding to the level of suffering that they were experiencing, rather than anything else. And in none of the cases did any of the hospitals feel that they had any therapeutic benefit to offer the child as a result of their ongoing detention. One thing I would note is, in terms of the alternative option, in half of the cases there was an alternative option. It was not a good alternative option, and in both cases it would have involved going back to the family where the child was considered to have been at very serious risk of harm, and where they left in the first place. In one case, the child would have had to return to a family where the mother's partner had strangled her. In another case, the child was repeatedly expressing a wish to kill his father. I think his father had been in many physical confrontations despite being of a very young age. So it is entirely right to say that there were no appropriate alternative options for these children, but there were alternative options. They did physically have another place that they could have gone at that point in time, but the court was clearly making a decision that the child should not go back to that place for very understandable reasons, given the extraordinarily high level of risk the child would face in that setting. The reasons for refusing the deprivation of liberty authorization, again, were consistent, that the courts could not say that it was in the child's best interest to remain in this setting. Particularly in the Wigan case, there's a very strong implication that if the court had been asked to determine whether Article 3 was breached, it would have found that Article 3 was breached in those cases. And again, that was specifically the case where the child was being restrained on a 5-point basis pretty much at all points in time, with 13 police officers coming in as well. Some of the more specific points that were made underneath the overarching heading that this was just so unacceptable as to be able to be said to be in the child's best interest was the lack of connection between the services provided for the hospital and the nature of the child's detention. These were all ad hoc arrangements. In most, I believe, at least 3 of the 4 cases, there were external staff that were not related to the hospital coming in to undertake restraint and care for these children. None of them had any link to the existence of the hospital or the medical treatment which was being offered. Something that Donald J. noted in the 2 judgments that are considered by him were that there were very few safeguards. One of the things that's often noted is, had a child been detained under the Mental Health Act, there's a very clear framework around restraint, around seclusion, around the way that the child would be treated, around use of chemical restraint. None of those existed in these cases. They were all just entirely ad hoc arrangements. People coming up with the plans on the ground, and certainly no statutory safeguard, because this was also being reviewed under a court, which was necessarily doing this some arm's length from the situation. The two judgments from McDonald J, they also expressed concerns that if the situation on the ground was authorized, they might go even further. So if there was some sense that this was acceptable, then the reality of the child's restraint might go beyond even that, which was already considered far too much for any 12-year-old child to have to face. One thing I would note is, again, in terms of concluding on the reasons in the Holman J judgment, one of the things he actually notes in refusing the authorization was that the hospital may have a defensive necessity in relation to their actions. While he would not offer her any formal authorization under the inherent jurisdiction, the fact that there was nowhere else for the child to go may help to defend it at some later point in time if the hospital did what would be reasonably considered had to be done in order to keep the child from serious harm or death. So just considering a few questions arising out of this. The first being the framework which these are considered and whether some option always has to be in the person's best interest. The second being whether the detention in the sole available option can it breach Article 5 without breaching Articles 3 or 8. And then really just more of a practical question of what should hospitals do if they find themselves in this situation where, again, as I say, these children had been admitted because they needed to be looked over after suicide or self-harm attempts, and then there was nowhere for them to go at the end of that. Tori is going to be talking more about what steps can be done about provision generally, so I'm not really going to be touching on that because it's really just about the deprivation of liberty authorization themselves. The case of North Yorkshire and Mag is mentioned in several of the judgments. This was a case from a few years ago by Cobb J, in which it considered an appeal from an order of District Judge Glentworth refusing a deprivation of liberty authorization in respect of Mag. He was a gentleman with significant physical disabilities who was living in a property that everyone agreed was inappropriate for him. He was a wheelchair user, but the whole of the property was so narrow that he couldn't use his wheelchair indoors. He was forced to crawl on the ground, which led to him having very painful bursitis. And his learning disability nurse considered that this was causing him both physical harm and emotional harm insofar as it changed the way that his carers looked at him. He was obliged to crawl on the ground and essentially robbed him of his dignity. This situation persisted for years, despite many attempts by the court to prompt action for the statutory bodies to review this, and finally the court simply said the judge said she simply would no longer authorize it. This was appealed to Mr. Justice Cobb, who reversed the decision, and what he set out was that there should be a two-part analysis considered in looking at an authorization of the deprivation of liberty. The first being whether it's in Mag's best interest to live at the property, noting that although he's deprived of his liberty, there is no alternative available which offers a lesser degree of restriction. And then the second part of the test being whether the accommodation provided to Mag was so unsuitable as to be unlawfully provided, breaching his rights under Article 5. Now, to my view, I think this is the correct framework for considering what's happened in cases of refusing the deprivation of liberty authorizations in respect to the children as well. What's happening in these cases is the court is not sending these children home to what would obviously be extremely dangerous situations for them. It has made some decision that there should be no further orders made. They were not, but again, not returned to their families. There's no order that these children should be removed from the hospital. The court was simply declining to authorize the deprivation of liberty there. To that end, I think what has to be read into this is some implicit determination that this is very unfortunately the only situation that the child can remain in. And there has been some choice made by the court there. But what the court is expressing is that this is so unsuitable as not meet the requirements of Article 5 to constitute a breach in that law. So I would offer a slight disagreement with the way that these decisions have been framed as far as they're saying that this isn't in the child's best interest. I think very, very unfortunately, these placements are in the child's best interest because there is nothing else that doesn't offer the child extreme danger. But the real question is whether it's so unsuitable as to breach Article 5. Considering whether or not the detention in a sole available option can breach Article 5 without also breaching Articles 3 and 8. The strong implication within these judgments is that the court is applying a standard which is very close to an Article 3 standard. Particularly in the Wiggin judgments, the court found that there was considerable force in the argument that Y's current situation breaches Article 3, where treatment is inhuman or degrading to purposes of Article 3, if to a seriously detrimental extent it denies the basic needs of any human being, particularly Y's current situation allowed to persist for any longer. that does seem to be very much the implication, is that this is a very similar standard the court is applying, and I think that probably is the relevant one. It's not been tested yet, and I think this is something courts may have to continue to look at, because unfortunately, the likelihood of having more children detained in very inappropriate settings in hospital has not gone away, and I think these questions will continue to come before the court, and there probably will have to be some definition of when they become so unsuitable as constituted Article 5. The final practical point before I hand back to Tor is just around what hospitals can consider doing in a crisis. What I would emphasize very strongly is this very fact-specific question. It's going to depend very much on what the hospital is able to offer the child, what else may be available for the child in the community, the level of risk that the child is at. And it's not something that's amenable to a yes or no answer by any stretch of the imagination. It will involve very close consideration of the Articles 2, 3, 5, and 8. Obligations of the hospital and the other statutory bodies involved. One case that I would note out, the ST case. This is a case that involved a young woman with learning disability and autism, considering Donald J. The hospital in that case had been advised not to admit in crisis in the place of safety by CAMS. The child had some ongoing involvement with CAMS. They felt that it would be very, very difficult for this child in hospital, and as it was, the child ended up extraordinarily distressed in hospital when she was admitted. Situation that the hospital found itself in was also unenviable. The family had presented to A&E essentially in a crisis, saying they could no longer care for her and refused to take her home with them. And the hospital then had to take a view as to what it was going to do in that scenario. And what they decided to do was, against the advice of the CAMS psychiatrist, they admitted her. However, there's a lot of criticism offered by the court for their taking this action, and the court required here a detailed explanation from the trust's local authority as to why the advice of CAMS, given that ST should not be admitted to hospital unless there was a medical need, as there is a clear risk of harm to her and others if she is admitted, and this is not an appropriate place of safety in crisis, was not followed. And again, the court really highlighting here that the hospital should have known this, that this was going to be the inevitable scenario, is this very vulnerable young woman in a very high state of distress because they admitted her to crisis. You know, as I say, I think it is very clear that it's not an enviable position, because what else could the hospital have done when a child was effectively left there by their family? But I think this is it's a telling point, and I think it is an interesting point in terms of foreseeing what the outcomes of these might be, and the hospital having to reflect on how long they can offer themselves as a place of safety, if at all, in a scenario like that, or to what extent they need to go back to the local authority and simply say, this is the advice we've had from CAMS, we're potentially going to need an Article 3 breach to get this child. Where do you go from here? But as I say, I think it is very fact specific. The final case I'll leave you with for handy facts for is the case of University College London Hospital, NHS Trust, and MD. This was a case that was decided right at the outset of the pandemic around possession of a hospital bed by a person who had it for 8 months while they were considered medically fit for discharge. The person argued that it would breach her Article 3 rights if she was discharged from hospital. Now, this is a different scenario to many of the cases we're looking at, because there was a 24-hour community care package available for this person. However, notwithstanding that, the court did find that the person would suffer, quote, extreme distress on being discharged, and that the risk of self-harm or suicide was at least moderate in the person's case if they were discharged from hospital. However, what the court decided in this case was that inpatient care is a scarce resource, and Article 3 was not designed for allocation of finite funds to compete with mass. So what essentially found is it is a decision for the hospital to take this view, and it would be very unlikely for it to be an Article 3 breach for them to say that a medically fit person was not entitled to the bed if they felt that it would be more appropriately suited to other patients. There's some complications around that case that I've discussed a little bit further in the paper, but I think it is an interesting one to look at, and I think it is worthy of consideration in some cases where hospitals may find that they themselves are perpetuating an Article 3 breach by continuing to accommodate a child.
Right, I don't have any slides because I hate slides. And what I have done is a very short paper with Steve's break, which is on the website, and you'll be able to read if you want to see at a later point. So what I want to talk about was something more positive about what we can do about any of this, because it does feel fantastically depressing. And worse than depressing, it also feels me anyway, as though we're all part of a system that's really not working, and the law might be really useless and not actually able to fix any of these problems. And even worse than the law being useless, that it's actually complicit in continuing what's happening and making things worse. So I want to try and think about slightly more positive suggestions about what could be done about any of it. And it's a very short paper as a result. But I'll give my best shot and try not to argue myself out of any of my suggestions immediately. In REX, the President's judgment from January, the President said, it's not for the courts and judges to determine matters of policy and the allocation of additional resources with respect to increasing the provision of secure accommodation places. All the courts can do is seek to draw attention to the problem in the hope that those who do have responsibility for these matters in Parliament and government will take the issue up and look to bring about a change in the current chronic shortfall in secure placements. So obviously that's depressing because the Parliament and the government have been asked to do that for years and have done not a lot about it. But it's also depressing because it's not true that courts can't do anything about this. It may well be true that the Family Division of the High Court can't do anything about it, but we have other judges and we have the Admin Court and we have human rights claims, and surely judges can do something faced with these really appalling situations other than just go, well, it's about resources and there's nothing you can do. And in the X case, the President did as much as he possibly could to force some sort of reaction and some sort of meaningful contribution from the government through the Secretary of State for Education. And when the response came back initially to him saying, oh, it's up to local authorities to sort out secure accommodation, said, yeah, that's not actually the answer I was looking for. Can you please turn up to court and say something a bit more constructive and engage with what's going on here? And eventually did actually manage to get the Secretary of State to admit that the significant problems nationally were such that the government did have some obligations to step in and do something about it. It couldn't just say, oh, well, you know, it's a problem of the individual local authorities. And that's kind of an important concession to have extracted from the government, because in a future argument in a different court, perhaps it would be more difficult for the Secretary of State to rock up and say, oh, it's just the local authorities, because they've now admitted that actually things have got so bad that there is something that they need to do. Unfortunately, all that they came up with in terms of what they're doing to help was capital investment that had been agreed in 2021 and asking NHS England to look around gaps in Canterbury. So that's sort of slightly positive because it's sort of it's forced a concession out of the government that could be used. But what kinds of other litigation could be brought, and what are the chances of any of them succeeding? The obvious one is to try and bring a claim against the government for the failure to ensure that nationally there's sufficient secure accommodation, on the basis that actually overall these are human rights breaches that are occurring systemically to children, and it doesn't, by the time one gets to Stratford, it's not going to matter whether it's the local authority or the government who's at fault, it's the state. And so the courts might need to look a bit more broadly at it. And even if the domestic courts don't, then perhaps Stratford would. I think the easiest claim, and none of them are going to be easy to bring, is one which just says there needs to be a plan that actually has some prospect of making a difference, and we haven't even got a plan. And to get some order from the court which says the government will at least come up with a better plan with more detail, with more content in it, even if you can't get something stronger out of them about current failures. The Good Law Project tried to bring judicial review proceedings fairly recently against 5 local authorities on the basis that they were failing to meet their sufficiency duty in terms of provision, and as a result, children having to be placed out of area. And that came all difficult against the Secretary of State for failure to then follow up on what local authorities were not doing and implement any of their powers. And they had permission refused. They didn't even get to losing their case. They didn't even get permission, which is pretty seriously depressing, because there clearly is a massive problem. And if you can't even get over the permission threshold in judicial review, almost imagining just pack it in altogether. But that wasn't a human rights claim, it was a classic judicial review claim. It was focused on children going out of area, not focused on children being sat on by 15 police officers in a hospital bed. You know, it's possible that there would be other ways of framing those challenges that might be more successful in at least getting over the first threshold of getting listened to by a judge. It's possible to imagine some strategic litigation where, having got the court, any court, to identify that there are human rights violations caused by certain familiar scenarios, such as children in hospitals with no medical need being there and being subject to physical restraint by police officers, that if those sort of unfortunately typical scenarios constitute breaches of Article 3 or Article 8, that if there are enough of those, that you might be able to persuade the court that the sheer numbers constitute a systemic failure. And even if you can't just rely on the numbers, which is always quite difficult, perhaps you would be able to rely on expert evidence and even evidence from local authorities themselves about the systemic problems and the other factors that are contributing to that state of affairs. So all of that is difficult, and it's not heartening to discover that you can't even get over the permission threshold for JR. But there's still options that haven't been tried. And my personal view is that this is all so awful that we have to try all of this. And if the ultimate answer is the law's hopeless and it doesn't help anyone, then that's the ultimate answer. But we can't kind of give up until we know that that's definitely where we're going to end up. The other issue that is possibly easier to implement, but possibly more controversial, is for the family court or the high court judges and the Doles Court judges to stop authorising things under Article 5. And Arianna's talked about a couple of cases where they've just said, when we're not willing to do this. But there are a load of other cases of children in community settings where they may not be subject to multiple police officers restraining them, but the care that they're being provided is really questionable, and there have been all sorts of problems with them escaping, harming themselves. I mean, there's just all sorts of really grim things going on, even in those cases. And once the court has been asked to sanction it, and they said, oh yes, Article 5, here's your order, it's in their best interest, that's that child's claim extinguished against those statutory agencies, because the court's now sanctioned it all and there's court order authorising everything that goes on. And so on the sort of immediate challenge that the child might have to the people who are inflicting this inappropriate care on them, that route it has gone. And perhaps the court should do what Mr. Justice Holman did in one of the cases that Arianna talked about and say, well, you might have a defence under Article 2 for keeping the child in this setting, but I'm not going to rubber stamp or authorise anything for the purposes of Article 3 or Article 5 or Article 8. And if the child then wants to go and argue about those in another setting, they're then free to do that. The other possibility, I think, is something that Alex will, from the later speaks, might look at, is that a lot of these children have mental health needs, obvious mental health needs. And okay, a Tier 4 CAM spec might be the worst place to put a child with mental health needs, but some of the other options don't seem like very good ones either. And yet in the Doles Court and the children's cases, very little attention in my experience is paid to which limb of Article 5 you're authorising this under, and to the question of whether any therapeutic input for mental health is actually being provided. That leads on to the possibility of some kind of claim in relation to the failure of CAMS provision, because why on earth have we ended up with a situation where children with severe mental health needs are being told, well, you can't have Tier 4 bed because that will just make you worse. You can't have any input from CAMS because you're not in a secure placement. And so you just get nothing for your mental health needs. Problems get worse and worse. You end up dumped in a hospital, or you end up in a caravan or wherever it is. But the thing that you don't have is any meaningful input to address your mental health needs, and the local authorities are then stuck being told by the mental health expert, well, until there's a secure, stable placement, there's nothing we can do about it. And they're saying, well, until you do something about mental health needs, there's not going to be a secure, stable placement, because the care provider is going to give notice every 4 weeks because they've been assaulted or the child's run off or whatever it is. And so the whole thing just sort of goes around in circles. And I was looking at for this talk at some of the sort of previous things that the government has said about CAMS provision. And back in 2015, they agreed that too often the mental health and wellbeing support offered to children and young people falls short, and accept there's a need to improve the current system, and set up a task force with a capital T, who said that by 2020 we would wish to see in every part of the country children and young people having timely access to clinically effective mental health support when they need it. Well, it's delightful, but of course we absolutely don't have that. We wouldn't have all of these cases, and so it's possible, I think, that there is something in there in terms of systemic failures and human rights education to do with the inadequate CAMS provision, which is possibly contributing, at least in some of these cases, to the setups that the children find them in, and then being trapped in this cycle where they can't get a stable placement or any mental health support, and so nothing can kind of break that and actually make anything better for them. So, obviously, there's a lot of questions about all of that, but we're not going to have them now, fortunately, because instead we're going to move on to Alice, who has come from the NFJO, who's going to do her presentation about what they've been finding about their research into the child roles course. There you go.
Great, well, thank you. It's great to be here today. So, as Tom mentioned, I'm Alice Berry. I'm a researcher from the Nuffield Family Justice Observatory. I should caveat my presentation by saying that I'm not a legal professional at all. I'm a researcher, so I'm not going to be talking about the law or case law. I'm going to be focusing on the findings from our research using data from the National Deprivation and Liberty Court. And to start with, just a brief introduction to the Nuffield Family Justice Observatory. The observatory was set up by the Nuffield Foundation in 2018, and we aim to increase the use of research and evidence in the family justice system in order to improve outcomes for children and families. We aim to work in three very connected ways, and firstly around developing the evidence base, so trying to identify and fill gaps in our understanding of how the family justice system functions and who is coming into contact with it. Secondly, we try and convene wide-ranging discussions with a range of professionals and those with lived experience of the family justice system to try and stimulate change in how that system functions. And then finally, we aim to use data and evidence as a catalyst for system change and try and support innovation and new approaches to ways of working in the family justice system. And so we work across a range of different focus areas in both public and private law. But our work on dolls is focused within our broader young people project. So this was launched a couple of years ago in response to the growing number of older children and young people who are coming into care. And this program of work aims in its kind of broader sense to look at how the family justice system and the child protection system need to change in order to better meet the needs of young people. And so recognising really that this was a system or kind of set of systems that was set up primarily to respond to the needs of much younger children coming into care due to issues within the family home primarily, but with this increase in older children and young people, their needs are slightly different, and the system may not be best set up to meet those needs. And so I mentioned this kind of broader context before I start talking about children deprived of their liberty, as this is really the kind of wider framework we use for our work on this topic, recognising that children deprived of their liberty are a group of children with particularly complex needs whose needs are being failed by the current system. But really a lot of the issues that we see in this group related to lack of provision, related to the type of care and support these children receive, as well as their opportunities to have their voice heard and to input into their care planning, are affected by many more young people in the care system more generally. So moving on then to the issue of deprivation of liberty, I'm sure most of you know, but just by way of context, the National Deprivation of Liberty Court was set up by the President of the Family Division in July 2022 and is running for an initial pilot period of 12 months. And this means that all applications to deprive children of their liberty under the inherent jurisdiction are issued centrally at the Royal Courts of Justice, and most applications will then go on to be heard by a core team of judges sitting at the Bill Court. And we were very lucky to be asked by the President to collect and publish data on these applications. And this gives us a really good opportunity to start to build a national picture about what is going on in terms of use of deprivation of liberty orders under the inherent jurisdiction. Before the court was set up, we really had very little national data and research about these applications. Data isn't published or collected by the Ministry of Justice or the Department for Education. So it was really only through published judgments that we could build a picture of who these children were and the circumstances in their cases. So what have we been able to find out then? So starting with the kind of simple question of how many applications there are. So this slide here shows the number of applications in the first 7 months of the court, so from July to January. And as you can see, there's been almost 800 applications relating to 762 individual children. So this is a really significant number of applications, and if they can continue on this level, as we expect them to do throughout the year, it will mean well over 1,000 applications being issued within a 12-month period. And if we compare this to applications under Section 25 of the Children Act, so to authorise the placement of children in secure children's homes, we see that applications to the Dole Court are now much more common. So in the period July to September 2022, there were 7 times more applications to the Dole Court than there were for secure accommodation orders under the Children Act. So far from being a kind of last resort measure, use of the inherent jurisdiction is now very frequent and is being used quite consistently by local authorities up and down the country. So the data that we've had access to through the Deprivation of Liberty Court has also enabled us to start to look at this question of who are the group of children and what are their needs on a kind of national scale. So last month we published an analysis of the first 2 months of applications to the court, trying to answer that very question and looking in detail about the needs, characteristics and circumstances of children and why the Dole application was being sought. So I'm going to run through some of the main findings from this report now, but I won't have time to talk about them all in detail. So if you are interested, I would encourage you to go away and read the full report. But starting then with that question of what were children's needs. And perhaps unsurprisingly, given what we've already heard today, we found that children subject to Dole's applications are highly vulnerable, and they typically have multiple and complex needs. So the application to the court was often made at a point of crisis, when children were at really severe and immediate risk of causing harm to themselves or others. And in most cases, there were multiple severe needs present. So we identified that in over 2/3 of cases, there were at least 4 or more what we term risk factors in our analysis. And this includes kind of common behaviours that were considered a risk to others. So this included kind of challenging behaviours, aggressive behaviours towards others, or causing damage to property that meant these behaviours were quite hard to manage in kind of community residential settings. There were also widespread concerns around mental health or emotional difficulties that children were experiencing, and this included both diagnosed mental health conditions, but often in many cases kind of suspected mental health conditions that hadn't been necessarily diagnosed. So we also found that a lot of these children had experienced significant instability in their living arrangements in the months and years preceding the application to court. Many children had been moved multiple times, so some children in our sample experiencing more than 10 different placements in the past kind of 12 months or so, often moving at very short notice, up and down the country, sometimes back into moving back in with family members who they'd been moved away from, and so very kind of significant instability, which isn't going to help any of these kind of wider issues that children are experiencing. And then also common experiences of self-harming behaviours and children going missing from their placements. So generally, children were well known to services, so most children had been on the radar of children's services for many years, for many of them kind of throughout their childhood. and children had experienced significant adversity and trauma throughout their childhood. So most children in our sample were in care, so over 96% were in care at the time of the application. And many had kind of repeated experiences of children's services involvements throughout their life. Again, kind of suggesting that there may have been missed opportunities to provide the kind of intensive support that children and their families needed earlier on. So moving then to the reason for the application, in our analysis, we tried to identify a kind of single main reason for the application in each case. And this was the kind of driving concern that was driving the application to court. And as you can see from the slide, we identified kind of 7 core categories. The most common reason was those behaviours that were a risk to others. So as I mentioned, including violence towards others and damage to property. The second most common primary reason related to issues around children's disability, so children with severe physical or learning disabilities, where some level of restriction was needed to kind of supervise them or manage their behaviours that arose from that disability. And then other kind of common reasons were around self-harm and mental health. So we only identified mental health as a primary reason for the application when there was evidence of a kind of diagnosed mental health condition and there was kind of significant input from mental health services in those cases. So obviously, as on the previous slide, there was much broader kind of mental health concern for these children. And then finally, concerns around exploitation were a factor in just under 20% of cases. So where children were at kind of severe risk of criminal or sexual exploitation, and deprivation of liberty was sought to manage these risks. So in our analysis, we also tried to identify if there were kind of distinct groupings of children by these needs. And the reason we did this was to kind of think about policy making and planning provision for this group of children. So to ask the question, you know, are all children who are subject to deprivation of liberty orders, these kind of 750 children that have been in adult bar, are they all the same and do they all need the same type of provision? Or are there kind of different cohorts of children within that large group? So we identified 3 different cohorts. The first was the most kind of distinct, and that related to children with learning and physical disabilities. And these children tended to, in most cases, although not in all cases, be in relatively stable placements. So they'd often be in those placements for a number of months. Some of them already subject to deprivation of liberty orders, and it was expected that those children would continue to be subject to restrictions on their liberty kind of throughout their childhood, with these cases kind of moving on to the court of protection when the child reached the relevant age. So the second 2 cohorts were much kind of closer and kind of tended to overlap slightly more. But that second group relates to children with multiple complex needs. That was seen to be the result of complex and ongoing experiences of trauma. And in these cases, children were considered to be very vulnerable and often at risk of multiple kind of overlapping needs. So this included concerns towards their mental health, kind of severe instances of self-harm and behaviours that were a risk to others. So where kind of all 3 of those risk factors co-occurred in these cases. And then the final group there was children who were more at risk of external factors. So while a lot of these children had also experienced adversity and trauma, and there were also issues related to their mental health, self-harm, to other behaviours, the main reason for the deprivation of liberty was to manage external risk factors, so particularly around criminal and sexual exploitation. And it was felt that without that kind of external risk to the child, otherwise the deprivation of liberty application wouldn't have needed to be made at that particular point in time. So finally then, in our analysis, we tried to look at the care plans for children, and I should kind of caveat this by saying that this data was looking at the information included in applications to court. So not looking at whether the application was authorised and the kind of alternate restrictions on a child's liberty or where they were placed. We're planning a kind of follow-up analysis to look at the legal outcome data So we'll be able to kind of comment on this more in that report. But again, kind of perhaps unsurprisingly, use of unregistered placements was very high. So just under half of children in our cohort were going to be placed in an unregistered setting. And particularly we found that children where there were issues relating to self-harm, to behaviours that were a risk to others, and to criminal exploitation were the most likely to be placed in unregistered settings. So perhaps suggesting that there's a particular lack of suitable placements for this group of children. So I've included a couple of case studies that are taken from the report. I think for the sake of time, I might move through these, but perhaps I can leave them up in the break. So to conclude then with some thoughts about what we as the observatory want to do next. So we're continuing to collect and publish data from the National Court, and we'll be doing this kind of throughout the duration of the pilot phase of the court. And we're also starting to convene some conversations at a national and local level to think about what needs to happen for these children, and really trying to ground that conversation in about provision, in an understanding of who these children are and what their needs are from research and data. So I think our research really underlines, as well as everything we've already heard today, an urgent need to develop new types of provision at a local level with joint input from children's services, from mental health services and education services. I think it's clear that there is not enough provision, and I think potentially not the right kind of provision that can meet the really complex needs of this group of children. So I'll finish that, I think. Thank you.
Brilliant, thank you, Anna. So that is the end of our first session. There's a 15-minute break now, in which real life people can have a real life cup of tea next door, and virtual people need to go and make themselves their own cup of tea, sadly. We'll be back at 5:02, or probably inevitably 5 minutes late, so more like 3 o'clock, but we'll aim for 5:02 when we're going to hear from Senior Judge Hilder. So I will mute this and hope you remember to unmute it when we come back in 15 minutes. Yeah. Right, welcome back, everybody. So the next session is going to start with Senior Judge Hilder, and we're very grateful to her for having managed to escape from First Avenue House long enough to come and be here and talk to us about a little bit, but from the perspective of fraud protection. So just sort out this screen. And hand over. Thank you very much indeed.
Hello, real people, and hello, virtual people, wherever you are. Thank you very much for inviting me. Thank you for holding this event. I think it's really important that people are having these conversations. Personally, it's always a pleasure to come out. They do let me out occasionally. But more important, I think it's absolutely imperative that the cohort of young people, which is a small subset of your wider discussion, I absolutely acknowledge that, but the small cohort that I'm concerned with is included in this kind of discussion. It's important for them as individuals, but I think it's also important for wider society, so that we understand the full picture of what is going on out there. There are important differences in the legal framework applied to deprivation of liberty for children and young people outside of fraud protection and to those within it. I'm not going to dwell on the comparison between the children across the inherent jurisdiction versus the Mental Capacity Act before this particularly one before the audience, it would be a bit reckless. But I do emphasise that the Court of Protection starts through the prism of its welfare powers. It's section 4A making that clear. Oh, I've got a little picture of it here, that's even getting a quick neck. And section 16.2 being the launch pad. There's a contrast to what is made clear in routine in the family court versus inherent jurisdiction, where they are falling over themselves to emphasise that they are not authorising the placement, only the declaration of liberty. Not quite so concerned about that. In the Court of Protection, to section 16, we are starting off making a best interest welfare decision from which the deprivation of liberty authorisation follows. And of course, the principles of section 1 apply. I practiced family law for about 10 or 11 years, and I don't think the phrase deprivation of liberty passed my lips once. For the first several years of my involvement in the Court of Protection, cases involving deprivation of liberty were both rare and considered to be of special gravity. The requirement set by Sir James Munby, President at the time, was that they all had to be referred for consideration at Tier 3 High Court level. And then came Cheshire West. And the issue became widespread, and the numbers just went through the roof, cases involving deprivation of liberty. And so obviously it was not practicable to require all of those to be referred for Tier 3 consideration. Overnight, literally, district judges were dealing with them. And in regional hearing centres, challenges to deprivation of liberty became, and they still are, the main work of fraud protection nominated judges. And throughout that time, the cases all concern adults, people over 18, and usually quite a lot above 18, kind of more near 80 really. Typically, they were elderly folk who had had full lives behind them, but whose faculties were declining with dementia, and they were typically being looked after in residential care homes. And they came to court as challenges to an administrative authorisation, and the focus was for measures necessary to keep them safe in the sense of not letting them wander, self-neglect, falling, or otherwise. Where they were younger, they were generally younger people with a pretty stable mental impairment, such as a learning disability, and they were being looked after in supported living settings, and they were generally uncontentious, and they came to court latterly through a specially developed streamlined procedure. For that reason, they were uncontentious, and the focus of the case was measures to keep them safe in the sense of being able to engage in the community and have as wide a life as they could. And then in 2019, the Supreme Court decided Read D. It's not within the scope of parental responsibility for parents to consent to a placement of a child over the age of 16, which deprives that child of their liberty. And the exercise of the inherent jurisdiction is required. And in court protection terms, if we're talking parallels, that's back to tier 3. There's a concurrent jurisdiction then between that setup and the court of protection in respect of 16 and 17-year-olds. It's clearly a concurrent jurisdiction because Lady Black said so, specifically rejecting the arguments to the contrary from the OS, but where court of protection jurisdiction was available, it would be to the exclusion of anything else. And it didn't take very long for the relevant authorities to come up with the idea that the court of protection might be a better, really in what sense, a better option for some of these cases. It was just 3 months after the Read D decision, December 2019, that we received at First Avenue House the first application under the streamlined procedure in respect of a 16-year-old. The factual nexus of the cases of 16 and 17-year-olds is materially different to those cases which the Court of Protection was pretty well practiced at dealing with at that point. This P is at a particularly difficult stage of life, transitioning from children's services to adult services. We know that that's a difficult period for families with young people with mental impairments, even when there aren't the kind of needs that lead to deprivation of liberty. We know that families at that point struggle with the sense of the whole legal framework changing simply on the flip of a calendar page when they see no material difference in the capacity of their young person. But these young people in these applications, they've had a difficult life experience to begin with. There are care orders in the background, more or less formally looked after children, but they are markers of challenges already. Or maybe they're beyond parental control. They're outside health and education provision. They've got a string of failed placements behind them. All of those aspects carry very different needs and risks to dementia and to stable mental capacity impairments. And this cohort are likely to have a lot of life ahead of them, as long as we do our job properly. Whereas the traditional cohort had most of it behind them. So we have to work out how to deal with these cases. And I tried my best to do that, thanks to helpful counsel in the Bolton and KL case. And it's never very attractive to focus on your own judgment. It's much nicer hearing it from Anna than it is to say it myself. It sounds sensible when it comes from her. So I'm going to read the analysis of that case to somebody else. But I'm particularly grateful to the Family Justice Observatory. Alice I've met before, Lisa Harker is meeting with me as well before, because they've been willing to engage with me, even though I'm nothing to do with the family court. And I would like to emphasise that the National Doles Court, I don't know its first name, I'm very pleased to see Alice calling it the Dole Court with no superfluous S, is nothing to do with the Court of Protection, although when it was first announced, it caused a fair degree of panic amongst Court of Protection practitioners. I'm bound to say that getting the Court of Protection cohort of 16 and 17-year-olds considered in all of that research has not been a foregone conclusion. It wasn't an automatic step. And that's why I'm particularly grateful to the Family Justice Observatory for being willing to engage. I'm certainly not aware that there was any engagement with the Court of Protection when the National Doles Court was being set up. And I will eventually get over my irritation at that meaningless S. So where are our applications coming from? Firstly, the numbers. The National Doles Court research is working on the basis of about 110 a month, so about 1,300 a year. In the same period as the Family Justice Observatory latest report, in a sort of two-line footnote almost, they say the Court of Protection reported 57 cases. So we are smaller in numbers, but I was particularly struck by Alice's statistic just now, which I hadn't picked up elsewhere, that when you identify the reason which brings people to the National Court, 22% of them have disability as their principal reason. We are not getting anything like 22% of the referrals of the rate of the National Dole Court yet, but does that mean that that's a stream of work waiting to happen, or is that 22% of the National Dole Court that are going to get lost next? I don't know, but it's a question that needs asking. When Arianna first mentioned this conference, and I think it was just about the beginning of December, which is conveniently the 3rd anniversary of us getting the first of our streamlined cases. So I thought, well, I've got to talk about something to this very well informed audience. I'll start counting. And so I have, from the 1st of December last year, kept my own detailed records. And it's these numbers that I'm going to share with you now. So 3-month period, more or less, we've received 40 applications through the streamlined procedure alone. So that's on average 13 a month, more or less 150 a year. There are some also being made by one application, including to the regional hubs. That's fine. I'm content with that to happen because it will be dealt with in the same way anyway. But my impression is that there aren't very many being dealt with that way. There's no way for me to keep count of that. So we have to think of my numbers as minimum rather than an overstatement. So by comparison to the National Doles Court, we're about 1/10 again of the number of young people, bringing the total somewhere up to 1,500 a year. And where are they coming from? Oh, I'll show you the page now. There we go. They've come so far from 2 ICBs and 25 local authorities. I did a quick Google search to see, well, how many authorities are there in England and Wales with the relevant kinds of responsibility? And Google tells me there are 333 in England and additional 25 in Wales. So 25 local authorities engaging in this procedure is very small. There must be a similar number for the rest of the authorities that have not so far engaged. 12 of those 40 cases came from 16 London boroughs. So London is accounting for about 30% of these cases. That makes it about twice as predominant as it is in the National Doles Court. I don't know why that is. It may be because the Court of Protection seems to have a greater traction in London than it does in the region anyway, and it might just be reflecting that. Interestingly, the Midlands is significantly more active in the Court of Protection cohort than it is in the National Doles cohort, although I have to admit that might be down to my sense of geography. I have, for example, included Norfolk, Cambridgeshire and Essex in the Midlands rather than the others. I'm not quite sure how this categorises them. But interestingly, the Northwest is very much less prominent than it is in the National Doles Court. And again, that is reflective of the level of engagement in other court protection issues of that region as well. Wales, interestingly, is more engaged in the Court of Protection cohort than in the National Doles Court. What about gender? What kind of young people are we getting referred to us? Well, so far of the 40 since the 1st of December, there have been 29 boys, 10 girls, and 1 transitioning young person, natal girl transitioning to male. In a totally non-scientific way and completely by way of generalization, my strong sense from those numbers is that they are reflected in care arrangements in quite stereotypical ways, according to the way behaviours that challenge manifest. Absolutely acknowledge this is a generalization, but my experience with these cases is that they're brought to court because girls self-harm and boys harm others.
At least that's the way the risks are presented in the care plans. What's the nature of the mental impairments that we're seeing? Developmental trauma echoes what Alice has been saying about the children feeling and very thought. Acquired brain injury, which is usually cerebral palsy, is the next biggest, and genetic conditions amount to about 12.5%. Learning disability, 40%. By far and away, autism is the biggest feature here. There is, of course, some overlap in those diagnoses. Often, these with diagnosis of with autism as their primary diagnosis also have learning disability. I've avoided double counting by only going with the primary diagnosis according to the evidence that comes with the application. The developmental delay group, only relatively small, but quite significant, raises very interesting issues about capacity, which take quite a lot of time to work through and inevitably independent experts. But that is an awful lot of autism. Are they subject to care orders or not? Well, 12 out of the 40 have been, so that's about 30% have extant care orders. And I think there's a lot of law to be worked out there as to where the limits of the parental responsibility of the local authority stop when the court is engaged with it. We did initially have one case where the local authority thought, well, okay, it's before the court doing deprivation, but I've got parental responsibility, we're still going to choose changes of residence. I think we've got that pretty quickly, but I think there's a lot to be worked out there. And 9 out of the 40, that's 7.5%, were living in the family home, and the rest were looked after children. So informally there with the consent of their parents. What kind of placements are being used? Just over 22% are still in their family home. 14 out of 40, so that's 35%, are in a residential school. That's the biggest cohort. The rest of them are in children's homes or foster placement type arrangements. What do I draw from those statistics? Well, it does seem to me that the requirements of Ofsted registration play a key role in reminding local authorities of their obligations to have proper authorization for deprivation of liberty. And a significant proportion of those the applicants in those variety of placements relate to young persons who are inevitably going to change placements. Those that are in the family homes are more likely to come with applications that say we've got no plans to change. The others are in placements which are going to have to change when they're 18, and it does seem that the applications have at their very heart an unspoken acknowledgement that it's really hard to find the next placement for Keene. And I get the sense that the court process is being used as a positive aid in situations where budgets are stretched, and getting a different budget holder to take on the financial responsibility is challenging. So I don't think that these applications come to the court reluctantly or with hostility, but sometimes looking for help. What kind of restrictions are being sought or authorized? That, I think, is the area where the different factual nexus of these cases plays out most starkly. And I share with Victoria the general sense that this is all very depressing. And it's led me to think that probably the title of my talk should really be summarized with a better, a different inflection. Not what are we doing with 16 and 17-year-olds, but what are we doing with 16 and 17-year-olds? Of course, all of the cases involve constant supervision and not being free to leave. And otherwise, apart from that cohort where P is living in the family home, just less than a quarter of them, the nature of the restrictions is where we see the difference of the factual nexus. There is far more physical restraint than there ever was in the Court of Protection before. And it does seem to me that it is considered generally common practice for care arrangements for 16 and 17-year-olds to envisage the use of physical restraint. Is that only in the cases that are actually being brought to the court, or is that a reflection of a general approach to young people with mental impairment? I don't know the answer to that, but I think it's a really important question to ask. My observation perhaps sets it out more openly than the application paperwork does. Often, you find there is no explicit reference to the use of restraints in written care plans that are filed initially with the application. And certainly you can't take a positive behaviour support plan for granted. But the COBDOL 11 application form for the streamlined procedure specifically asks the question, is restraint being used? And as set out in the Bolton case, that's one of the reasons why, in my view, even though it's almost certain I'm going to take it out of the streamlined procedure, actually I think it's quite good to use the streamlined paperwork for these kind of applications. The answer to that question on the applications that have been filed is 13 out of 40, some 32.5% tick the box yes. So if you take the cohort of the Ps that are living at home and family home, that percentage rises to 42%. But then in my experience, a significant number actually acknowledge use of restraint once you've gone through the process of disclosure of records to P's representative. So I am concerned that social workers, before proceedings are issued, often do not have, or at least do not express, a good grasp of what restraint is being used on the young person, in what circumstances, in what fashion, and by whom. And all too often, it's only the court process that actually brings that to light. Where the application does explicitly seek authorization for the use of restraint, it's been honestly eye-opening to me to learn what the practices sometimes are in place on the ground before anybody thinks it's necessary to seek lawful authority. Thankfully, it's not typical, but I've had one case where the request was to authorize 5-to-1 supervision 24 hours a day, and another where the request was for 7-to-1 supervision 24 hours a day, and the use of restraint contemplated supine restraint on 16 and 17-year-olds. The expense of that kind of care package is, of course, enormous, but the risks of that kind of care package to the young person are also significant. And simply on a practical basis, I struggle to see how it works. What are we doing? 16 and 17-year-olds. Now, the 7-to-1 case has newly arrived, and I don't yet have any insight to offer into it. But the 5-to-1 case involved funding 5 carers to spend their days and nights in a property just down the road from where 17-year-old P was locked in, living effectively isolated, for the reason that he reacted so badly to having carers around that they had to be distant, but yet still there to respond to a crisis. And they monitored whether there was a crisis by periodical mobile phone messaging. There were frequent crises, including frequent police involvement and physical damage to property and injury to persons. His mother in reality was still bearing the burden of care, even though care at home had broken down. There had been no involvement of the family court or the inherent jurisdiction, and no authorization for this situation as it developed over a period of almost 12 months. We've now got nearly to the end of that case, and the situation has been addressed by the public authority effectively funding the entire family to purchase, they provided extra capital funds, a larger house where an annex has been built for P, and the family is managing much smaller package of care by direct payments. There's no use of restraint, and P is agreed to be doing really well. it's difficult to see how the situation at the time that that application was made was ever allowed to arise. But it's difficult even more to see how it would have improved without the proceedings of the court framework. When the social workers involved struck me as entirely well-intentioned at every stage, but utterly overwhelmed. That's not how this system is meant to work. But on that less than encouraging note, I conclude my remarks, but I'm very happy to answer questions at any time.
Gosh, well, thank you very much indeed, Judge. It's actually, I mean, I think this is the first time any of us have heard any in-depth analysis of what the cases are before the Court of Protection, and it's so valuable. So thank you very much for doing that counting and that analysis. I should say one person's voice I was hearing very, very strongly as you were speaking, Senior Judge Hilder, was the late official solicitor, Alistair Bicarregui. He was very, very challenged, to put it politely, by the fact that CAFCAS, when D was age 15 in the case that went to the Supreme Court, when D was in a mental health hospital, and the Mental Health Trust came to the court saying, we're really not sure it's appropriate having D here with no formal legal arrangement, save for his parents saying it's okay. He was challenged by the fact that CAFCAS didn't make any observations at all about whether or not D was deprived of liberty at that stage. He found that quite challenging. I must say, I find that quite challenging too. It's fair to say what he did then try and do when D turned 16, and the case came before Mr. Justice Keene in the Court of Protection, was say, you got it wrong last time round, Judge, when you heard this case about 6 months ago, and Mr. Justice Keene said, I can't go there. Alistair tried to run the case again before the Court of Appeal, but Mr. Justice Keene had got it wrong, and the concept of deprivation of liberty should broadly apply exactly the same for under 16s as it does for over 16s. Court of Appeal didn't go there. Supreme Court in Re D, absolute cut-off. Once you hit 16, no one can consent on your behalf. Observations from Lady Hale about the pre-16 cohort. Many judges running quite hard in different ways, as Camilla is going to talk about, in different ways, away from that as a concept. But I do have to say, and I put in the supporting materials here, which you can find online, I think these cases are reflecting the way people operate in silos. Different conceptions of what liberty means at different ages. And the reason I put it, there's an extract from a quote from a speech given by Sir James Mumby, where he talks about, when we come back to look at all of this, we may be slightly troubled by the fact that they're looking in silos with people of different expertise. This isn't a desperately happening story. And actually, just hearing what you said, Senior Judge Hilder, isn't it striking? The cohort of people that you're getting, very many of whom people may not have thought there was a problem at all, until someone somewhere told them, you know, there was this Supreme Court decision you do actually have to pay attention to. And if you go into many facilities, they've never heard of it. Nobody's heard of it. It's actually quite, I have to say, it's alarming. You're getting lots of applications into the COG. It's alarming how few you are getting. And then those applications just coming through, what you're then seeing in terms of, right, actually, this is considered entirely normal practice. Hello. I'd also just flag in terms of the missing numbers that you were talking about. The Children's Commission, the previous Children's Commissioner, Anne Longfield, was very troubled about this area. And if you read the 2 reports she did, where are they? On the hidden missing children, really trying to dig into, where is this cohort of people? And nobody's mentioned, I think there was one very brief mention from Anna right at the beginning of LPS. We haven't the first clue what's going on with LPS. But what we do know is that some authorities, some ICBs, some authorities are beginning to really get their act together and go, oh my gosh, there are a lot of people here we're having to think about. So as part of that auditing, I suspect, is showing why there is a slow increase in numbers, because I had a quick look at the Where Are They Now report, and I think in 2019, 2020, MOJ thought there'd only been something like 60 applications to the Court of Protection to authorise deprivation of liberty. So it's definitely going up, it's just miles off. So it's a sideline point I wanted to make. It was that we don't know where they all are. Right? The other point I wanted to make, because I really don't want to talk very long, because I'm much more interested in what everyone else is going to say. I want to hand over to Camilla. The other point I wanted to make is going back to the fact, and I think it was Anna alluded to this, it is quite striking on the under 16 cohort. So this is portraying the fact I'm really a 16 plus, not a 15 minus person. I find it really striking. If you look at the standard order that's wheeled out in the family division, following Sir James Mundy, re A to F, the standard order to authorise deprivation just says in the child's best interest. It doesn't say on what basis, as a matter of law, are you complying with Article 5 of the European Convention on Human Rights. The supporting materials here will back this up. Austin in the UK says it's an exhaustive list. You've got to pick one. Article 5.1d, educational supervision, is not the same as Article 5.1e, deprivation of liberty on the basis of mental disorder. I do find it quite challenging. It also shows wonderfully how little influence I've got. I've repeatedly said, why does the re A to F model order not require you to pick a side? No one's listened. But at least going back to McDonald and is depriving someone of their phone, deprivation of liberty, analytical clarity allows you to think through why are we doing what we're doing and on what basis is it justified? And if this is to be crude, a mental health detention, well, why aren't we thinking about the Mental Health Act? And I know Camilla's going to talk more about this in a second, but can I just please make the point? Mental Health Act detention does not depend on the availability of a bed. It depends on, do you meet the criteria for detention? I really hope Mrs. Justice Lieven, who is currently fighting this fight quite hard, actually gets the Secretary of State for Health to turn up and explain how Tier 4 gatekeeping is working and how it complies to the Mental Health Act. But I don't want to step too much into Camilla's territory. I will just finish by saying, not only do we need to know the basis on which we're detaining, whichever limit is, makes it very clear. Detention on the basis of educational supervision, Article 6, it's got to be in an appropriate place. Detention on the basis of Article 5.1e makes it very clear. Appropriate place, appropriate treatment. These are kind of non-negotiable. Obviously, you then get into the question, what do? Do you simply not authorize and let the institution swing? Or do you say we're going to come up with some coherent reason why, notwithstanding there's nothing else which can be done, and we're not really offering anything here, it's still okay. Which goes back to the questions posed by the first panel. So I'm going to draw stumps there and then hand over to Camilla. But I think it's quite important that throughout this, it's had any questions here, because this is the theory of the question.
Well, thank you very much. Well, I think after hearing everything else, I'm sort of thinking, what more can be said about this issue? I hope that I am going to be able to say more, but I think a lot of what I'm going to say is really sort of picking up on other people's points. But first of all, I just really wanted to explain the title. So I've got Deprivation of Liberty, Children, Young People, Human Rights and Decision-Making Dynamics, Child, Parent, State. Because I think sometimes when I don't know about you, but I feel sometimes very overwhelmed when we get to talking about this issue. And there's so much for us to all think about. And it's almost like we need to be able to hold the big picture. And I'm really pleased that, Victoria, you were talking about the role of mental health services, because that's quite a big issue for me that kind of tends to get dropped out of the picture, but they are very, very much in that picture. We've got to think about the big picture. Think about the fact that we're talking about children, and I usually talk about children and young people as my title suggests, but I do think it's really important to emphasize under the United Nations Convention on the Rights of the Child, a child is somebody aged under 18. And sometimes one kind of feels that that there is that kind of weird distinction that we're making with 16, 17-year-olds, and suddenly they're different and need to be treated differently from under 16s. And I think one of the drawbacks of that is the under 16-year-olds have become, if you like, the forgotten group. And it's really important that we think not only about 16, 17-year-olds who come into the nice fold of the Mental Capacity Act, and we can sort of talk about how the Mental Capacity Act works, and then they can, then sort of talk about the differences between young people and adults. But we also need to think about under 16-year-olds and the situation for them, and ensuring that they have their rights protected as well. So that's one main point I wanted to make. But the other point, this decision-making dynamics, it's really important, I think, when we're thinking about under 18-year-olds, that there is a difference in terms of how law operates, how human rights operate, and that is that there is a relationship between the state, the protected role of the state, the role of parents, and the rights of the child within that human rights framework. And I sometimes think that perhaps this is part of the difficulty. It's trying to work out how that balance needs to be framed, how we need to work through the issues, remembering that balance. It's not to exclude parents in the decision-making framework. It's very much to include them, but to recognise that parents had a particular role, but that was in the context of respecting and promoting the rights of the child. So my starting point, as was say, this context, well, we have a crisis. There's no doubt about that, and we also have conflicts, and we've touched on some of them throughout the presentations. I think there is a potential conflict, it seems, between the role of the local authority and the role of the NHS, and I think that is something that we need to be exploring in more detail. There's also a lot of confusion, and again, we've touched on this, and the reference to, I think, the pedants among us, and most of us are lawyers, so that's what we do, but we get very annoyed when people talk about dolls, children being subject to dolls, and no, that's deprivation of these safeguards. And why I think it's important that we need to think about that and try and explain that is because there's still a lot of confusion, as I will talk about a little bit more, about the basis on which a deprivation of liberty is determined. So we need to, I think, always reflect that people come from different backgrounds, they have different knowledge, different interests, and we need to work together to understand where each other comes from and work through some of these areas that I think are still, despite the many cases that we've been seeing over the last 5 or plus more years, there's still a lot of confusion about what amounts to a deprivation of liberty. And one of the things I want to talk about is why that's so important we get that right. But another point is, I think what the discussions that we've had thus far have demonstrated is that we need to have a concerted response to the situation that we have been talking about this afternoon. And thanks to the Nuffield Family Justice Observatory for doing such sterling work on looking at the applications that have gone to court. And it's brilliant that we've got a dual court that is with judges who are focusing on this the situation of under 18-year-olds whose care arrangements mean that someone is saying, oh, do we need to think about whether there's a deprivation of liberty? So it is that through such work, and it's not just them, the Children's Commissioner has also done a huge amount of work to bring this to light. And I just named but a few, but it's really good that we are having this discussion. And what you can see, I think what's very clear from the presentations we've had thus far, is that what we're seeing we're finally shining light on the failure of the system of care for children and young people who have complex needs. And it's also important, and again, the Alice's presentation, I think, really helpfully highlights that we shouldn't then bundle all these under 18-year-olds into a group of complex needs. They are individuals, and I want to stress that they're individuals. We need to think about them as people who have particular needs. And when I say particular needs, that's often going to be covering social care needs, it's going to cover perhaps special educational needs, it's also going to cover mental health needs. It is not one agency that should be involved in these cases. And they are different with them, and I think Alice's sort of 3 cohorts, I think, is really valuable to recognise that, yes, they come under this complex needs label, if you like, but we need to think about what they as individuals, what their needs are and how they are going to be responded to. So collective responsibility, what I mean by that is really picking up on Victoria's points. We need to think not just the Department, but the Secretary of State for Education coming along to explain things. This is a responsibility of other departments as well. In particular, I would suggest we've got the Department of Health and Social Care, we've got NHS England who should be very involved. But ultimately, if such a case ever got to the European Court of Human Rights, it would not be interested, well, other than looking at how this occurred, but it would be saying this is a state's responsibility, not trying to tease out which agency of the state was at fault. It would be saying, here's a situation, look at this, look at the violations of these children and young people's human rights. So, as I said, complex needs requires a multidisciplinary, multi-agency response. Social care, health and education, and joint working. I mean, I don't know how many, I think some of us here might be able to tell you how many pieces of legislation we've got about joint working. Well, does it work? It seems not. So we need to use some of these provisions to talk about the importance of agencies working together. But the other thing I'd like to say is how important it is that those of us who have got an interest in this issue come together and talk to each other. So thank you very much, Arianna and colleagues, for putting together this presentation. It's such an important start to having that conversation. I know Alice and co at the Nuffield Family Justice Observatory is also doing similar things. I think the Children's Commissioner has, as I said, really helped to highlight these issues. So we need to work together and recognise that we've got different skills, different knowledge, different experience and expertise that needs to come together to try and work out how we're going to address this. Because as Alex had said, what we see is an interplay of whole area, complex legislation. Some of us know quite a bit about some bit, but not others, and vice versa. But it's also about policies, different policies that impact upon different aspects of the complexity, education policies, social care policies, health policies. Some of them don't recognise each other. Some of them may impact conflict. And then obviously there's issues around funding, because I think we're going to need to look at how can we work together to try and start talking about the services that are going to meet the needs of children and young people. And I want to bring us back to that's what we should be doing. We should be asking, well, what is this child or young person's needs? How can they be met? And then the question will be, do the arrangements that we're putting in place to meet those needs, do they give rise to a deprivation of liberty? And I think it's good that I actually think it's good that we're seeing these applications coming to court. They're high, but that's, I fear, is just only a partial amount of what is happening across the country. And there needs to be far more awareness of identifying when a deprivation of liberty arises. So yes, absolutely, it's not the only right in town, Article 5, but it's a very important right. And what it's doing by recognising that care arrangements for that under 18-year-old give rise to a deprivation of liberty, it's then engaging a scrutiny of the care arrangements and highlighting, as we have seen in some cases, the fact that actually we're doing a very, very poor job at meeting the child's or young person's needs, and asking, well, what's wrong? How can we address those problems? How can we address those gaps? And so the process of determining a deprivation of liberty is a crucial part of ensuring respect for the child and young person's rights. So I want to say a little bit about that in itself. Article 5, deprivation of liberty. Why is it so important? Well, because, would you believe it, all of us have the right to liberty. and it doesn't matter what age we are. And it protects us from arbitrary interference with our liberty, and only allows the deprivation of liberty in certain specified circumstances. And again, Alex has mentioned this. We need to be clear as to what is a justification for the deprivation of liberty, and that in many cases is not happening. So we need to understand on what basis is this under 18-year-old being deprived of their liberty, what is the justification for this? And then also it safeguards, and that is why it's so important that we recognise the deprivation of liberty. And this is also why it is of some concern that for under 16s, we seem to take a different approach. And I'll say more about that in a moment. But if the care arrangements are not recognised as being a deprivation of liberty, then it doesn't engage Article 5, so we're not concerned about whether those arrangements are put in place in accordance with the procedure prescribed by law. There is no right to have a review of that, or the lawfulness of that detention. We have seen over the years, particularly since Cheshire West, the importance of looking at whether the health and social care arrangements for an individual, whether an adult in Cheshire West or whether an under 18-year-old in the case of RED, whether those care arrangements give rise to deprivation of liberty. And Mr. Justice MacDonald was very forthright in a case in 2020 in the saying how important it is for if there's a deprivation of liberty or care arrangements might give rise to a deprivation of liberty, then authorization for that deprivation of liberty needs to be sought. So 3 key areas of concern. I've tried to reduce it down to 3. And I suppose to some extent I've had to just of necessity give a fairly broad picture. But first of all, what I want to talk about is the state. So remember, I had the relationship between state, parent, and child. And first of all, in terms of state responsibility, well, the state as a whole is responsible for the provision of care for under 18-year-olds. And one of the things that I have sort of reduced what I'm going to say about this, because I think actually we could take a whole seminar on this one, I think there needs to be a greater transparency on the process of decision making in relation to what are the child's needs and how are those needs going to be addressed. That is a process that happens before matters that go to court, but often it's not clear as to how those decisions were made. And one area that I am particularly concerned about, and thanks to Alex for flagging this up, is this relationship between the Mental Health Act, and we heard about many cases where the detention or admission to hospital was not considered to be appropriate. And I'm not for any second suggesting that that children need to be in a psychiatric hospital, or this is how you address the problem. I'm not suggesting that, but what I'm saying is we're often not clear as to why admission to hospital is not thought appropriate. We've heard some very good examples where there was that discussion and it was clear, but sometimes it's not clear. And then sometimes there is this sort of suggestion, well, the Mental Health Act is preventing us from doing this. Now, if you look at the Mental Health Act, if you're talking about a decision that somebody does need to be in hospital for assessment or treatment of their mental disorder, the criteria for the detention are met, then the Mental Health Act can be used, but also that would only be used if formal admission wasn't required. There have been, in the Blackpool case was an interesting case where the mental health assessors, who I should stress, it's not just 2 doctors, but it's also usually what's a person referred to as a approved mental health professional, who have AMPs have a huge amount of experience and expertise in relation to assessing people to determine whether they need admission to hospital, and then decide what's the legal basis for that admission. Can they be admitted informally, or do you is informal admission not appropriate because there's no consent, or the admission amounts to a deprivation of liberty. So that is something that would be gone through, and the assessors, being the approved mental health professional and 2 doctors, will spend time, all 3 of them will meet with the person concerned. Part of what they'd be looking at would be, is there an alternative way of addressing this person's needs through provision in the community? And there's code of practice that sets out a very clear way of how that process should be undertaken. So it's striking, and this is all really I can say today, because I think this is an area that we need to look at more closely, and it's very helpful to know that we have other cases in the sort of being considered where hopefully this will be teased out. But I think it is really striking that we have very clear legislation in the form of the Mental Health Act and the Code of Practice that sets out how the mental health assessment is undertaken. And then if that's thought that the Mental Health Act is needed, an application will be made supported by 2 doctors, but can only be made if the hospital can be named. And this is one of the things that happens and has been noted by earlier presenters, in that we have, in addition to for CAM, so Children and Mental Health Services, we have an additional, if you like, process that would need to be gone through before the admission to hospital is permitted, and that's the access assessment policy. One of the great things about the Blackpool case was it, at least I think probably for the first time, really highlighted that this is something that happened. But I would stress that, and I don't know the situation, that particular case, it looks like the young person concerned was seen by the people who were making that decision in terms of access to a tier 4 bed. But sometimes it's not, it's done with on a paper-based exercise. So you have the assessment process under the Mental Health Act, and then you have a paper-based exercise and looking at the form that the assessors have to complete to then decide whether admission to hospital is the appropriate course of action. And that it may well be that those looking at the access assessment, following that process, which is a policy process, not a legislative process, it may well be that they're right, but we don't have the information, we don't know how it works, and I think it would be really helpful and important if we have a greater understanding of that process, and then there can be some engagement with those who are trying to work out, well, what is the best intervention for this under 18-year-old. Another issue with mental health is, I think when we're looking at these issues, please don't forget issues around mental health for under 18s. We still have young people and sometimes children placed on adult wards. We have children and young people sent out of area. And these are issues that we're basically seeing this sort of, certainly with the adult ward placements, that this is inappropriate settings. What we need to ascertain is on what basis is this happening. And then again, another point for mental health is the invisible children. So I'm going to pick up in a moment in terms of parental consent and deprivation of liberty. But for under 16s, we could well have children being admitted to a psychiatric unit informally, i.e. either on the basis of their consent or parental consent, and they do not have the safeguards that they would have had if they had been detained under the Mental Health Act. And I think that we need to recognise that. So there are what the Children's Commissioner said are invisible children, because we don't have any collection of data in terms of how many are admitted informally. And that's, I think, something that's particularly important when we're thinking about parental consent rather than a child's consent, but also whether, and again, the Children's Commissioner identified this, sometimes when she was talking to teenagers who are in psychiatric units, the impression one might get is that they weren't really consenting. They've just been told, if you don't consent, we'll use the Mental Health Act. So that's the points about the responsibility of the state. Then the voice of the child in the decision-making process. This seems to be a huge gap. We need to do and require far more in the process. Seeking and taking into account the child or young person's wishes and feeling is something that in other parts of law we're doing. The Children Act requires that. Those decision-making for young people under the Capacity Act, best interest will require that. Making decisions about medical treatment by the courts will very much focus on the wishes and feelings of the child, but we don't get that sense that that's coming through the cases. And I've just given you one of the points made by a legal blogger who just said, during the short hearing I attended, I didn't get much of a sense of the young person at the heart of the case. And that, it seems to me, is a huge gap. And then parental decision-making powers. I'm going to say more about that, but I think we need to have greater clarity on the limits of parental control when considering if a deprivation of liberty has arisen. So this is where, just talking about the interrelationship between the protective role of the state, parental responsibilities, and the evolving capacities of the child. It's for the state to respect the decision-making role of parents, but this has to be balanced against the responsibility for protecting children's rights. Then both the state and parents are required to act in the child's best interests. That is something that goes through, it's a thread that goes through the human rights treaties, not just the Convention on the Rights of the Child. We've also got that for the Convention on the Rights of Persons with Disabilities, and the European Court has highlighted that as well. The other point is that it's expected that parents act in their child's best interests. Again, that's a right mentioned in the right under the Convention on the Rights of the Child. It's also something that under national law is very clear. So the views of the child are important in themselves. The Article 12 of the Convention on the Rights of the Child highlights that and requires states to give weight in accordance with the age and maturity of the child. But the other point is that it's something that under national law I've mentioned is integral to many decisions being made under the Children Act, medical treatment of cases, and the NCA. It's also something that parents need to be aware of and think about, and this is where it's linked to the role of parents. Their role is to assist children in exercising their rights by giving appropriate direction and guidance in a manner consistent with the evolving capacities of the child. So what that is getting at is, yes, we recognise the role of parents, very important role, but their role in relation to their child is to assist their child in their child engaging and exercising their rights. And as that child grows and develops and heads towards adulthood and takes on more decision making and for themselves, the role of the parent diminishes. So that's one point that we need to think about. But the other is, and I'll come on to that, is thinking about how this all relates to deprivation of liberty. So another area of potential confusion when you talk about deprivation of liberty is what Sir James Mondy referred to as the terminological imposition. And why he was saying that was because you sometimes get discussions about talking about this first, the stalk test, which is the objective component of confinement in a particular restricted place for a not negligible length of time. Quite a mouthful, so I just call it the confinement question. You quite often get that referred to as being the deprivation of liberty, whereas it's not. Under Article 5 terms, that's just one component of whether there is a deprivation of liberty. So it's really important that we think about stalk and we recognise these different elements. And the second one is that you would then talk about the lack of valid consent. And then the third is the state responsibility. All three are key, but we have a low threshold for state responsibility, And it would seem to me that probably where we've got to is if the question is being asked, is there a deprivation of liberty, then the state is responsible. Because it's not just where the state is actively involved in the provision of care arrangements, but it's also if they know or ought to know of the situation. And I'll say more about this in a moment. It's like we need to avoid the conflation of stalk A, the confinement question, and stalk B, the consent question. That is particularly important when we think about the role of parents. Both engage the role of parents, but they're looking at a different aspect of parental decision making. And I'm going to come on to that, but before I do so, I want to just talk about the what I call the false economies, because this is a number of things I think it's important to be aware of. So one of the things that is quite curious to see in many of the cases is the kind of the lurking of the Nielsen and Denmark case. Very, very old now, 1988 was the decision. And often the judges will say, well, is it stalk A, i.e. was it all about the fact that the boy was not thought to be confined, or was it stalk B, there was not a deprivation of liberty because the parent had consented. Well, it is, as has been said in the Reedy, the Supreme Court decision in Reedy, it's a little artificial given that it precedes stalk by many years, nearly 20 years. The court thus far has not, there's plenty of opportunity to say, well, that was an old case, we're not in, we're going to, things have moved on. It might do that if it actually gets a case relating to a child, but it hasn't thus far. It has made comments about Nielsen, and you can see that actually stalk A and B both kind of have components you can see in Nielsen, and the European Court of Human Rights itself has mentioned that. So in Guard in the United Kingdom, the court said, well, actually the kind of restrictions placed on this young boy of 12 were sort of similar to what you would see in a hospital ward for physical care. In relation to consent, in the case of Stanov and Bulgaria, the court said, well, actually with the exclusive custodial rights being exercised by the mother over a child who is not capable of expressing valid opinion. But remember, this was pre the United Nations Convention on the Rights of the Child. Then we have the under 16s and those aged 16 and over, and it's quite difficult really to know quite how to express this, but I think we just really need, starting point is that they're all under 18, they're all children for the purpose of the Convention on the Rights of the Child, and for the Children Act as well. But when we're coming to look at deprivation of liberty, it's not the fact that in Reedy, the Supreme Court decision in relation to a young person aged 16 or 17, the age was not the determining factor in the court in Lady Hale saying parents cannot consent to the confinement of this 16, 17-year-old. Her view was that there was no principle of substituted consent in the European Court of Human Rights. And quite often people refer to legislation, and yes, legislation does increasingly make a difference between 16, 17-year-olds and under 16s. But not in relation to parental consent when we're looking at deprivation of liberty. So we have to question, why are we making this distinction? And certainly Lady Hale, again, as Alex mentioned, she was sort of saying, well, her logical, she felt, suggested logically, her conclusion that parents can't consent to their child's confinement would apply to an under 16-year-old. But she then very, very quickly then said, well, we're not discussing that here. So we have very clearly got a current case law that says it may be possible for parents to consent to their child's confinement. But when we're thinking about this, we need to bear in mind this is not about parental rights versus the role of the state. The state mustn't interfere with the rights of parents, nor parental rights versus the rights of the child. Parents are exercising their decision making on behalf of the child. And we have to, when we're looking at that, we have to think about that interrelationship between the two and the fact that there are limits to parental decision making. So when we're thinking about the parental decision-making powers, we first have got the state responsibility question. I deal with that first because I think you'll be saying, yes, this is a situation where the state is responsible. Therefore, the two components that we have to look at is the confinement question. And this is where we need to ask, well, what are the restrictions being placed on the child? How do they compare to the restrictions you would expect to see for a child or young person of the same age without those disabilities? That is what Lady Hale said in Re D. While I think for 16, 17-year-olds, I think that the acid test can work very well because, you know, what 16, 17-year-old would be under constant supervision and control and not free to leave. Whereas you know, for under 16s, they're not going, none of them are free to leave. The restrictions, but what we should be looking at, certainly for under 16s, is the point that Lady Hale talked about, is are the restrictions, you know, do they exceed the normal parental control for a child, child of that same age? And if they do, then we go on to ask about, you know, is there any consent? So it is possible for a young person to consent to their confinement, which would mean that they're not deprived of their liberty. It's also possible for a child to consent to their confinement if they've got competence to do so, so they're not deprived of their liberty. The difference is for the under 16s, whereas for a young person who lacks capacity to make a decision about their confinement, they will be deprived of their liberty because they can't consent to it, and nor can their parents. Whereas for under 16s, the position is that it is possible for the parent to consent to their under 16-year-old's confinement if the child is not competent. Then that's the next bit. And then we have to ask, well, what else? And that's where we have sort of interesting points made in terms of saying the parent could not consent if the child is subject to a care order. So the courts have been saying that that's not possible. Neither local authority nor the parent could consent to the confinement if there's a care order. But what we don't have is what is the position if you've got a child not subject to a care order who lacks competence to make the decision. When is it possible for the parents to consent on behalf of their child? And this is where, thus far, courts have talked about parents exercising parental responsibility, the proper exercise of parental responsibility, acting in their child's best interests, and more recently talking about, well, yes, that's fine as long as no one thinks the deprivation of liberty is contrary to the best interest of the child. And it seems to me that we need to think a little bit more closely about what do we mean by best interest and what are the limits of parental consent. So with Nielsen and Denmark, it's often referred to as being controversial, but if you go and look at what happened, it was a 12-year-old who was in a child's psychiatric hospital, but very, very, you know, the restrictions are very few. As I said, the European court said it likened it to restrictions in a general pediatric ward. The court in Nielsen made very clear that there are limits to parental decision-making powers. And also, that decision was pre the Convention on the Rights of the Child. So it's the only case, it's still the only case that looks at under 18 children in these circumstances, which we're talking about, in that case, a hospital admission. But we don't, the rationale for the decision is not clear, and it's a very old case, and it certainly is nowhere near talking about the restrictions in Nielsen and Denmark, but nowhere near the kind of restrictions we just heard about this afternoon. Substituted consent, as I said, Lady Hale was very clear that there's no principle of substituted consent. But I think Lady Hell acknowledged that there are cases where the court has sort of said, well, a third party could consent, where evidence shows the person was willing to stay, where he or she was capable of expressing a view. But, and I think this is a really, really important part, there have been cases where the court has held the person could not consent to the individual's confinement if there's any sort of expression by that person who's confined that they're not happy with the situations, trying to leave, or giving any indications that they are not, that is not where they want to be. And that is something that then brings me into the views of the child. Going back to the importance of thinking about the views of the child, we need to think about best interest. Best interest must include taking into account the views of the child. Article 12 talks about sort of taking into account the views of the child in accordance with their age and maturity. And also, if you think about Article 8, it's very clear that the European Court expects people who are the subject of decisions to be part of that decision-making process. So we need to go back and look at how thinking about the circumstances in which parents can consent to their child's confinement. I think we do need to look at, first of all, the level of restrictions being placed on the child, and also looking more clearly, seeking the child's views and taking those into account. At the moment, we've got too wide, or rather, there's insufficient clarity on when parents can consent to the confinement of the child. And also, one might argue they shouldn't be consenting at all, because if you're saying actually the restrictions have gone beyond normal parental control, then you say, well, in what circumstances is it appropriate for parents to consent to their child's confinement when anybody age 6 and over, that's not something that's permitted. Okay. So concluding remarks, well, first of all, just to throw in something maybe of interest, in the UN, the admission of a child or young person to an institution of care would be considered to be deprivation of liberty, whatever the parents' views. But we need to think about increased awareness of when care arrangements give rise to a deprivation of liberty, and clarity on those issues about decision-making, collective responsibility, and collaborative engagement. So finally, and sorry, I realise I've talked too much, we need to put the child or young person at the centre of this decision-making process.
Brilliant. Thank you. You haven't gone on too long. We started 5 minutes later, so it's done a perfect sign, perfectly, I think. So the next bit is just time for a few questions and answers before the tea phase of the afternoon. For boring technical reasons, I'm going to have to look at the Q&A on this screen because I can't make it work on my phone. I looked at a few in the break, so while I'm looking at these, I'll just kind of throw them out. The bad news is if you want to answer, you have to come and get me one of these microphones, I'm afraid, so you can't just sit there calling out your responses. So one of the questions was what will happen with liberty protection safeguards, but I think we're just going to move on from that because nobody has any idea. Another question was about what do you do with a young person who's over the age of 16, doesn't lack capacity, but doesn't want to agree to being accommodated. And then a question following that, what do you do about depriving some of their liberty after the age of 18 if they have capacity? And the two things sort of link in, I think, because you might technically be able to deprive some of their liberty under 18, even if they have capacity. But if it's an ongoing situation that's going to persist after they turn 18, you might wonder what you're doing, asking the court to authorise it for a couple of months, knowing that when the point of the age of 18 is reached, all those arrangements are going to fall away because you don't then have any legal authority to do it. And I've certainly seen cases like that where you think, well, what is the point of this application? Because as soon as this person turns 18 in a fairly short space of time, you don't have any of these powers anymore. You could try and persuade a High Court judge to exercise the inherent jurisdiction to deprive them of liberty over the age of 18 who has capacity. You'd have to hope very hard you didn't get listed in front of Mrs. Justice Leaven. And I'm not sure that any of the judges would really go terribly far down that path. And so actually, then you start thinking, well, maybe the care arrangements that are in place for the 17-year-old aren't the right ones, and you need to be focusing your effort on what you are going to do once they're 18, not focusing your effort on authorising the ones that you currently have in place and then falling off the cliff at 18.
And getting another capacity assessment in possibly at
Yes.
that point.
Yeah, yes. And that's a whole other seminar, is the different approach to capacity assessments in relation to children in the family court and the High Court in family cases as compared to the capacity assessments that you would see in the court of protection. Right. Before I as I try and wade through the online questions, does anyone in the room have a question? Yeah. I will repeat it so that people can hear. I hope this will work.
It's just like the Mental Health Act, the white paper that really identified the disproportionately adverse experiences of Black adults in mental health services, and that also is reflected in terms of the experience of Black children and greater use of restriction and so on. So obviously there's really fabulous work taking place in terms of research, and Alice, gave some insight into that. I'm just wondering whether the nuances in terms of racial disparity are also being picked up, because if that's applying when young people are of school age and so on, going to carry on into adulthood. And also, just very quickly, the use of restraint is a huge worry. Many may be aware that the Department of Education has launched a consultation in terms of use of restrictive practices in schools, which may help because and it's limited terms of reference, but restriction becoming normalised when children are in school is probably likely to increase the likelihood of that being part of their normalised care packages and so on, care plans when they move into adult provision. So I would hope that there can be some attempt to build on the fact that we've at least got this consultation starting. It's not ideal, I know, but restraint is just such a huge issue that I think it might be an opportunity to try and campaign and have some impact on how it impacts in terms of deprivation of adults.
And so just for the benefit of the room people, and this is obviously ridiculous simplification. So the two questions really, one about whether or not racial differences are being picked up when people are looking at this. And Alice, maybe you could say something about that, because we know, unsurprisingly, sadly, that Black children are going to be more likely to be subject to restrictive practices and some of the more kind of, possibly even abusive practices that are seen. Which leads me on to a question I had to Judge Hilder, which is when is the Nuffield Court of Protection Justice Observatory opening up, so that we're not dependent on Judge Hilder having to trawl through the cases, doing her own analysis and doing excellent pie charts, but in addition to having a full-time job. And the other point was about the current consultation in relation to restrictive practices in schools, and the very valid point that these things do totally get normalised, and it becomes accepted that this person needs this kind of care and this kind of restraint because that's what we've done, and therefore it must be proportionate and necessary because that's what we've been doing for the past 2 years, rather than actually challenging it. So do you want to come thinking about the race question in relation to the work you're doing?
So yeah, it's a really great question. Thank you for asking. We did in our report try and look at the ethnicity of children subject to applications within the DOLCOT. I didn't include it in my slides for time, but also, unfortunately, that data was missing for around half of applications, which is something that we're trying to change as far as we can at the observatory. But what we did find where there was information about children's ethnicity was that there was no overrepresentation, particularly children from mixed ethnic backgrounds, and some from Black ethnic backgrounds, and also children from Gypsy and Roma traveller backgrounds. So it's definitely a question. I think because we had so much missing data, we weren't able to look any further at whether the reasons for the applications differed in those cases and whether the deprivation of liberty that was being applied for differed according to ethnicity. But we are hoping kind of through the DOLCOT that we can try and improve the recording of ethnicity data and to try and make that kind of required piece of information in the application, which will then enable us to look at that question in much more detail. But we do, as you said, know the children in secure children's homes, children under the Mental Health Act, children in custody settings, who are also subject to restricted disability, that there is huge kind of ethnic disparities in that.
Can I just say just one thing? I mean, not to add to that point, but it's incredibly important. Just on the consultation on restricted practice, having been at a workshop on the last time, the DFE last time they were going around on this, it was like wading through treacle, because such different understandings of what's confinement, what's restricted practice, and you just get people I mean, it was absolutely awful having to spend, explain to people, you're just completely misunderstanding what the law says before you even get to that. So completely agree, please respond, but please respond on the basis of the greatest respect. People receiving it are very unlikely to have a clear idea of the sort of issues we're talking about today. So really go in there, and best consultation response is always tell stories, because I actually just brings it home. But no, thank you, Angela, really, really important point.
There was someone else who had up, yes.
I just wanted to ask, in terms of differentiating and making applications to authorise deprivation of liberty for under 16s and 16, 17-year-olds, I find in our practice there's quite a fine line between whether you apply to the inherent jurisdiction of the High Court or the Court of Protection, and particularly for 16-year-olds when they've just turned 16 or they're 16 and 17. So do you have any sort of guidance, or what's the best way to sort of differentiate that, and whether to apply to the High Court or the Court of Protection specifically for 16-year-olds?
Yeah, I'd be really interested to know what Senior Judge Hilder is willing to say about that question. I think so. One of the considerations sometimes applies in choosing whether to go to the Court of Protection or go to the High Court. In other situations, is whether or not the person is going to be able to have a litigation friend who's going to be eligible for legal aid, and they're going to be able to get their representation. But this usually doesn't crop up as much in these cases, because most of the 16 and 17-year-olds who will go to Court of Protection are probably going to be eligible for legal aid, because they're not going to have means above the threshold. And so that probably isn't going to be a kind of factor in it. And I usually go say, well, if you think these students are going to go on beyond the person's 18th birthday, and you can already see that at the beginning, then why not just start in the Court of Protection, because that's where you're going to be, and you don't then have to transfer, and you've just got, if you're lucky, one judge dealing with the case and all of those sorts of things. But I think if you've only just turned 16, you may not know about that. And if the liberty protection safeguards ever come into effect, then maybe you won't be in the Court of Protection necessarily after the age of 18, because maybe you won't need a court authorization for deprivation, because there'll be a community option that can be done under the amended legislation. So I don't have any kind of brilliant answers to that. No one else have any better thoughts. No.
The only point I would say is my continual bugbear that best interests for children isn't very well thought out, whereas at least we've got a statutory framework for thinking about best interest under the Mental Capacity Act, just in terms of the rigor of thinking. And going to Camilla's point about centering the voice of the child, is completely clear if you're in the Mental Capacity Act. Of course, practice-wise, it comes relatively close, but statute trumps.
If you couldn't hear that, that was Alex saying that the Mental Capacity Act is better than everything else. So, looking at the online, oh, sorry, hang on, I'll do the real life questions and I'll come on to these online. Yes.
So I just had a quick question about the cases where the authorization was not allowed. Arianna, I'm just wondering, was there any indication in the judgments about what options were left following the refusal for example, the acute trust involved, and more importantly, the patient?
I mean, in all of the cases, there were reports from local authorities talking about what they were doing to try to throw placements in the community. And in some of them, there were placements that were described as embryonic or listed. We've contacted the following 377 placements, and none of them have said yes. But so I think, all of those cases, it looked like what they were going to was going to be some sort of bespoke accommodation for the child that they would then have to run around and get registered for the offset that was going to be built really from the ground up, was where it looked like for all of them are headed.
Arianna, sorry to kind of before you run away. And just on that, thinking about the cases where you've got children, young people in hospital beds because there's nowhere else for them, I completely agree that the worst situations for the child, for the young person, because they're in a place. But I think that probably comes second closely followed by the hospital trust, who are in an almost impossible position in that situation, because if they don't house the child, and it is just housing the child realistically at that point, they're likely to face an Article 2 claim if something terrible then happens to the child if they don't. If they do house the child and the dole isn't authorised, they're opening themselves up to an Article 3, Article 5 claim with sort of rock and hard place for the hospital trust.
I mean, very much so, and I think this is something that was picked up from Holman J case, and I talk about this a bit more in the paper, where what he says explicitly is, I'm not telling this hospital to discharge this child, I'm refusing the authorization. But, and I think this is where he ended up going down the role of, you may have a defense of the doctrine of necessity if there was truly nowhere else for this child to go. But I mean, I think it goes back to what Tor was saying earlier about, and I think this is one of the difficulties the court is facing, if you authorize this and you say that it's all right, where do you really go from there? You know, where is that child left? And I think again, the point that I made earlier about, it is going to go even further. And I think this is actually one of the other questions of, it's very difficult to say what is actually going to happen on the ground once that authorization is granted. And if we already say that it's all right, this child is here on 5-1, getting constant chemical restraint, the police are coming, handcuffing them, and that's acceptable. You know, I think that there is a real worry from the court is it just going to ratchet up from there. And I think it's very difficult to say that it won't, because you know, you're already dealing with extremely difficult situations and people who don't feel they should be looking after this child in the first place. And I think it's the whole situation just goes very unmanageable. But I think the doctor necessity question is an interesting one. And I mean, be curious to see if more cases do end up with the courts just saying, no, this is just unsuitable. You know, what do hospitals do from there? And do they think that do they have an Article 2 obligation to keep looking after it? But I think this is where I came back, and I would say this is my overarching point on this. I think it will always be very, very fact specific to what's going on, how bad the situation is for the child, and what else can potentially be done on the ground.
All right, and I'm just going to try a couple of the online ones. We're definitely going to run out of time for all the questions. But there's a comment from someone who was previously an AMP saying that they think that the gatekeeping policy for the tier 4 beds is a real problem and doesn't work in practice. And also someone who's a business assessor pointing out that in the context of adults under the DOLS system, you have conditions on a standard authorization. So you can say, well, this isn't a person of interest, but you've got to make sure that these things are happening, which then is a sort of useful mechanism for making sure that things don't you do remain proportionate and that things happen. And I suppose because there's no statutory framework for any of this where the High Court's exercising its inherent jurisdiction, that can happen in those cases because the court can say, well, you have to come back every fortnight and these things, you know, this bit of care plan has to be amended. But there isn't sort of there isn't such a kind of clear formal mechanism for making sure that those sorts of conditions are in place and for anyone to monitor them beyond just having repeated court hearings, which is, you know, what you end up with. But that's not actually sustainable given the numbers of people that could be involved. So you sort of wonder at what point in the, you know, possibly before the pilot ends, people say, well, actually, we can't have hearings every fortnight in all of these cases because there aren't enough judges to deal with it. And at what point does First Avenue House and the regional courts become completely overwhelmed with the number of people who actually require court authorizations? Judge Hilder, the question possibly more of a complaint about the difficulty for the court admin staff at First Avenue House, but interestingly suggesting that actually the preference is to issue COP 1s in the regional hubs rather than to issue COP 11 through the central thing, which might mean that there are many more, I guess, cases going to regional hubs that you're not able to keep track of.
I don't think that is a generalised view.
Right.
I have very regular conversations with all of the regional judges, and I think they are still fair as hen's teeth.
Right.
Really, got ones for 16, 17 or whatever. They're happening, but
Yeah.
not on the scale.
Not on the scale you would expect.
First Avenue House is not entirely paper-based these days. We are making glacial progress. There are long delays in some areas, but not in any areas, and I can't resist the opportunity to put in a plug for the new EP&A Property and Affairs Deputyship system, which has no delays anyway, where it has a turnaround of about 4.5 weeks at the moment. The reason why the first hearings for the 16 and 17-year-old cases are listed by telephone is because with the following wind, the OS gets on board and the first directions are now fairly standardised, they can be agreed and approved on paper, and a lot of them therefore vacate. I find that we can list 25 matters in a week if we list them by telephone. We can list only a fraction of that number if we list them by Teams. The other reason is that where you're having family members come, you can't assume that they have Teams access, where you can more or less assume that they have telephone access. The second and subsequent hearings are never by telephone. It's the first one to establish the.
Hopefully you heard that online, but to explain that it's possible to list a lot more hearings by telephone in a week than it is by Teams, and given that a lot of them vacate, that's a sensible way of trying to get through things. I'm always tempted on a telephone hearing to adopt an interesting accent from another country, just so that it's very clear who's speaking it, which is I have to stop myself from doing it. There was something else. So there was a question about safeguards and how, once these orders are made, what's the sort of process for actually monitoring and reviewing what's actually happening on the ground. And again, at the moment, that does happen, I think, whether you're in the Court Protection or in the High Court Family Division. But it's kind of extraordinary that a judge is spending time every few weeks looking at a case and deciding whether the restraint's appropriate, when you think that the case has gone from, as Judge Hilder was saying, 5 people, having someone locked in a house and being down the road with no one overseeing what was going on, to suddenly a judge looking at it. And it's really, it can't be the long-term solution, can it? That
It isn't.
a judge has to do all of this in such detail for everyone.
I mean, just by way of contrast, Germany, no deprivation of liberty is ever authorised administratively.
Yeah.
Every single person gets a hearing before a judge. I mean, really, we've just set it up culturally that the proposal, I mean, the way we're now doing it sounds really odd.
Yeah. We've gone past the time for tea, which is unacceptable. Thank you all for coming or watching. Thank you for all the questions. If you had a question that didn't get answered, then just find one of our Twitter accounts or email addresses and try asking it again, and we'll try and answer it. The people who are here in person, there is tea and coffee in the reception where you can make it yourself with fancy machines, but there are also soft drinks and snacks that way, which is probably more important at this time of day. Thank you all again for coming to the slides, and papers will all be on the website. If they're not already on it now, they'll be on it in the next couple of days. Yeah, thank you everybody, and good luck with all of the slightly depressing things that we're dealing with.